All right, good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is September 21st. This is our Wednesday business meeting. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Bogue.
Here.
Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Messner.
Here.
Commissioner Oath. Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Great. Great to see everybody. We've got a bit of a full agenda. We did not have anyone sign up for public comment, nor did anyone provide written public comment. Would remind the world that we had set up public comment for this evening to accommodate our folks. But since no one signed up, we will not have an evening meeting. And so we will not have public comment, which is fine. We now will turn to commissioner comments. I would alert folks, I am the representative from Colorado to the Interstate Oil and Gas Compact Commission, and the yearly meeting is next month, and the call for resolutions went out. And at the last meeting, the resolution that was fostering carbon capture, sequestration, and utilization expired, and I volunteered to write a new one because we believe that's positive for the state of Colorado and the nation. And so I submitted that, and we'll see if we can obtain the votes for a CCUS positive resolution to the federal government. So note that that was out there. I think that's the end of my commissioner comments. Does any other commissioner have comments for the good of the cause? Commissioner Messner?
Thank you, Mr. Chair. I'm live streaming from Houston, Texas today. Had the opportunity this morning to speak at the Onshore Well Site Facilities Congress here. The Facilities Congress is a conference that discusses ways to reduce emissions, leveraging new technologies, and optimizing operation efficiencies around oil and gas operations and activities. My talk today was a talk about the evolution of oil and gas regulations in the state of Colorado. I was on a panel with regulators from both the federal level and the state of Texas. And so it's been a really good conference so far. Excited to be here. And I think the discussion today was good.
Fantastic. Thanks for representing and providing the Colorado perspective to our fellow sister states. That's always a robust topic.
Well, and I think one of my favorite comments, and this was from a gentleman who works for an operator in Weld County, took me aside as I was making my way back to the room for these hearings, and he indicated how proud he was to be an operator in the state of Colorado. And I think that meant a lot. So
That does. That's worth the trip right there, John. Thanks. Any other commissioner comments? Okay, seeing none, we will roll into our consent agenda. Does anyone have questions on consent? Seeing no questions, do we have a motion to approve consent?
So moved.
Second.
Motion by Commissioner Ackerman, second by Commissioner Cross to approve consent agenda. Is there any further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? All right. Consent agenda carries. We now will move into a presentation from Chevron Noble on the Wells Ranch CDP order number 1-241. Good morning, Ms. Fulcher.
Good morning, Mr. Chair, and good morning, commissioners. Great to see you all this morning. If you give me just a second, I will pull up the slide deck we have for you today. All right, do you have the slide deck in front of you?
We do. And Ms. Fulcher, if I'm sure you're going to do this anyway, but if you could kind of give context for the presentation,
Yes.
that would be helpful.
Absolutely. Happy to, Mr. Chair, and that's going to be the start of my remarks. So great to see you all this morning. Again, my name is Jill Fulcher, and I'm an attorney with the law firm of Beatty and Wozniak here today on behalf of Noble Energy. Got a few folks with me this morning from the team. First, I've got my partner, Jim Martin, that's with us. We also have Patricia Meinerich, Chad Calvert, and Luke McCartney listening in from Noble. I'm going to be walking us through the slide deck today, and you should have all of this in your packet already. But then we are all available for questions at the end of today's overview, should you have any. So our presentation today is aimed at providing you with an overview of the Wells Ranch Comprehensive Drilling Plan that was approved by COGCC back in March of 2020. And the Wells Ranch CDP marks one of two comprehensive drilling plans that were established by the commission under our prior rules. So prior rule 216. And under that prior rule, that was really the foundational model for what are now known as comprehensive area plans, or CAPs. I think the commission's very familiar with those. Many of you were involved with the mission change rulemaking that actually established Rule 314, but then recently have had cause to review CAPs that have come before you. Since the implementation of the mission change rulemaking, this commission's approved over 30 oil and gas development plans. However, none of those OGDPs have been part of an established comprehensive drilling plan, or CAP, to date. So beginning next week, Noble will begin presenting you with the first of 12 OGDPs within the established Wells Ranch CDP. And that really is what's giving rise to our overview presentation today, because next week will mark another important first step for this commission and for the regulated community, as you are asked to review an OGDP that's been part of a larger comprehensive plan approved by this commission. And so what we wanted to do ahead of those hearings was provide you with a little bit of a refresher about the Wells Ranch Comprehensive Drilling Plan, both in terms of the scope of the project, the lands themselves, and a little bit about how the CDP and this approved CDP will interplay with your review of the OGDPs. Some of you, I know the chair, then Director Robbins was involved with this CDP. Commissioner Messner was sitting on the commission when this CDP was approved. But since that time, we have new commissioners with us, and it's also been a couple of years since this plan was approved. So we wanted to provide you with the overview ahead of the substantive hearings beginning next week. So moving ahead, advance our slide deck here. We want to start by illustrating the comprehensive drilling plans that have already been approved by this commission in the state of Colorado. Again, what this slide is showing here is that Chevron Noble's development in Colorado is really built on the foundation of comprehensive planning. Up until recently, there were only two CDPs that were approved statewide, both of them by Noble, and you see those here. One is the Mustang CDP. That was the first CDP approved by the commission in 2018 to the south here on the map. The next is the Wells Ranch CDP in the middle of the map here, and that's the subject of our discussion today. And then the third comprehensive area that's underway for planning is the West Pony State Unit. You may recall approving that state unit last summer for primary recovery operations, but your order directs Noble to establish a CAP for the West Pony area, and that is underway. And Noble is also now looking at other areas for comprehensive planning. So as the industry leader in moving forward with these comprehensive plans, Noble has seen real direct benefits of this type of landscape level planning with respect to utilizing infrastructure to minimize impacts to our neighbors and to reduce cumulative impacts, adverse cumulative impacts, and to increase beneficial impacts. We've really seen proof of concept here, which is why this is really the model that Noble Chevron will carry forward with its plans moving forward again. This slide was really just for pre-reading for you all and for reading maybe in the week ahead. Again, just basically underscoring what I mentioned on the previous slide. So I'll advance here. We want to then drill down a little bit further into some of the realized benefits that we've seen from comprehensive planning by focusing in a little bit on the Mustang CDP before I move over to Wells Ranch, because the Mustang CDP, again, was the first CDP approved by the commission in 2018. And so implementation of the plan is well underway. And what we've seen is that by utilizing this type of landscape level approach to development, Noble's been able to obtain 100% facility electrification and over 90% drill rig electrification in the Mustang CDP, and that's an area of 64,000 acres of land. We've also been able to pipe all product and all oil, gas, and water, so that utilizing those infrastructure plans and that size and scope has eliminated all of those attendant truck trips, which of course has benefits to the environment and to emissions, but also to our neighbors. Utilizing the CDP approach also has reduced our surface footprint and emissions by over 90% and 95% respectively by utilizing an operational corridor approach to designing the facilities. You're going to hear a lot about that in the weeks to come, but Noble's operational corridor approach means that we are looking to tie in as many well pads as possible to a single facility, at times developing 4 or 5 drilling and spacing units from one single standalone facility. Again, looking to reduce impacts both on the surface and to our neighbors as much as possible. And again, to date, it's been about 200 wells that have been drilled in the Mustang. So we anticipate these types of benefits carrying over to the Wells Ranch CDP, and at least these types of targets being hit when we start implementing the Wells Ranch CDP in the weeks ahead. The other thing I want to mention before I move off of this slide is the table to the right. You're going to hear me speak to this today, but then certainly our witnesses will be speaking to this in the weeks to come for the specific OGDPs. This table to the right speaks to Noble's plugging and removal program. And we call it that because, of course, we're plugging some old wells, but then we're fully reclaiming the pads themselves and the facilities, and then restoring all of that land back to original vegetative state. And as you can see, we've had hundreds of legacy wells that have been plugged and removed in the DJ since 2018, with hundreds more to come in the years ahead. And it's really because of comprehensive planning that Noble's able to accelerate the plugging and removal of those old legacy wells. And that, again, has huge benefits to our neighbors and to the environment, to our community as well. So we're going to speak to that at a little bit greater level in this presentation, but wanted to highlight that for you here. So what this slide is meant to underscore before we dive into the specifics of the Wells Ranch CDP is to provide you with a little bit of context about where the CDP sits in relation to the prior rules, and then in relation to SB 181, because it's very unique. It's the only CDP that was approved during the pendency of the mission change rulemaking, but after the enactment of SB 181. So as I mentioned, it was prior Rule 216 that governed this particular CDP, but the CDP itself was filed after the enactment, as you can see here, of SB 19181, and also after the director's objective criteria were published in April, May of 2019. And so what we wanted to drive home here is that Noble really had the benefit, while we didn't have the benefit of knowing the final rules and submitting under 314, the Wells Ranch CDP was modeled after the changes made to the act. So it really wasn't modeled after the act as it stood prior to April 16th, 2019. It was all looking forward to the legislature's revised mandates for this commission in protecting public health, safety, welfare, and the environment. So there were certain aspects of the CDP that were made part of that plan that weren't required by rule, but that Noble voluntarily undertook to, again, aim for the revised statutory mandates. So even though, for example, Rule 304 wasn't yet on the books related to alternative location analysis, that alternative location analysis was part of the statutory changes to the act. So we took care to invoke a great siting analysis back in 2019 based on the objective criteria at the time. And likewise, many of the objective criteria that served to kind of bridge us to where we are today with respect to the mission change rules, a lot of those have been made part of our final rules. And again, were considered whenever Noble was looking at locations to make, to propose to you as part of the plan. But we also wanted to mention, this will be the last time that this commission is asked to permit projects within a CDP, because this will the last CDP that is ever was ever considered by the commission under the prior rules. So this slide provides you with a little bit more context and overview of the order itself. The order that established the CDP is order number 1-241. And again, bears repeating that the order was entered after the statutory changes were made effective to the act, but also the application itself and the CDP was prepared after the statutory amendments were made. Again, all with the goal of the revised mandates in mind. A couple of things that the CDP included that were required by rule, but were undertaken by Noble. Again, the CDP included a siting analysis based on the director's objective criteria. That's Exhibit P to the CDP. The CDP also included a master mitigation plan. And how this plan works is it enumerates 179 unique mitigation measures that when a location triggers even one criteria, those mitigation measures are deployed. So that's part of your final rule or your final order and the final CDP. And the CDP also included a comprehensive cumulative impacts plan. So it looked at cumulative impacts, both positive and potentially adverse, over the entire 41,000 acres of development area. So again, a first of its kind look into those issues. Certainly, I'm not going to read you all this text. There's a lot here, but what we wanted to do as part of your reading materials today was pull out some of the language from the director's finding of suitability that was made part of that final order. The director and the staff, we recognize, gave a very deep look and analysis into this particular CDP, recognizing that it was being reviewed by the commission and adopted by the commission during the midst of the rule change. And a couple of things to note here is that the director found that the CDP was compatible with the revised mandates to the act to regulate oil and gas in a manner protective of public health and the environment. And the director also found that the Wells Ranch CDP identified measures to avoid, mitigate, and reduce impacts to the environment. We really think it was the director and staff's analysis that helped get us to the point where the commission felt comfortable in granting that unanimous approval of this CDP. All right, so now I have a map for you, diving a little bit deeper into the lands themselves. So this slide here demonstrates the entirety of the CDP area. You can see that each of the OGDPs, and there will be 12 that we intend to submit over the course of the project, are color-coded here. OGDP 1 is the first you'll consider at next week's hearing, and that's at the bottom left hand of the screen here in blue. A little bit about this acreage. This is, of course, a map of the area, not an aerial image, but we wanted to give you a little bit of background here. First off, while this area is named the Wells Ranch CDP, the lands themselves are actually not in Wells Ranch. They are a mixture of homes and farms. So there's quite a bit of diversity of ownership here, both with respect to surface owners and mineral owners. But these lands are in no means urban. So this is largely rural acreage, or entirely rural acreage, really, in unincorporated Weld County. So there's no municipalities in these lands, and there's also no municipalities proximate to this acreage. It's all unincorporated Weld County. The lands themselves comprise 41,000 acres. So that's how much will be fully developed through implementation of the CDP. And that acreage covers 32 drilling and spacing units that will be developed by this plan. An important thing to note, each of those spacing units has already been approved by the commission. So when you move forward to look at the oil and gas development plans in the weeks ahead, you'll notice that there's no request to space the lands because that has already been accomplished as part of this development process. But nevertheless, 32 spacing units to be developed. The order itself designated Noble as operator of the acreage and also established a primary term of 10 years. What I did not include as a bullet here, but I'm going to discuss momentarily, and another important element of the order, is that the commission granted conceptual approval of all of the locations within the CDP acreage. And so similar to a Rule 314 cap, where an operator can request preliminary siting approval, here, of course, we didn't have the benefit of that exact language, but here the commission did grant conceptual approval of the locations. And we'll talk a little bit about what that means here in the slides ahead. So I certainly won't walk through each of these elements on this CDP timeline, but what we wanted to underscore here is the length of time that this process has been ongoing. Really, it officially kicked off in February of 2019. So it's been over 3.5 years roughly of the process to date for the CDP development. And it obviously is ongoing with the OGDP process. So this process that's been undertaken by Noble and by our stakeholders is by far the longest ongoing permitting project to date with the commission, and one that's yielded the highest number of public outreach opportunities, which Noble is very proud about. So to drill down into that just a little bit more, we want to speak to a couple of those outreach opportunities. First, there have been 2 public open houses with all of our residents and neighbors in this area. One occurring back in 2019, another in just a few months ago, in 2022, excuse me. The years are blending together. Each of those open houses, direct invitations were mailed to all residents and tenants within the CDP area, not just those within 2,000 feet of the proposed locations, but everyone in the CDP area was invited to that CDP open house or those open houses. Direct phone calls were made, follow-up phone calls to make sure we had great attendance there. In addition, there's been multiple outreach attempts and direct outreach with all of our owners through invitations for comment, through opportunities to petition, through direct conversations. So in the weeks ahead, we will summarize those for you on an OGDP basis. But I did want to underscore that we've had 100% contact with all of the residents and tenants within 2,000 feet of these locations. And what you'll also see is that there's been relatively little, if any, comment against this project. And we really think that this speaks to the ongoing direct outreach and engagement we've had with our stakeholders, that they've been overwhelmingly supportive of this project. So again, we see this as being one of the most public and transparent processes to date, again, with some of the longest direct ongoing outreach efforts that the commission has seen. And again, something that Noble is very proud to continue with respect to outreach for our neighbors. And this slide is just some images of, I think, the most recent 2022 open house with the invitation that was provided to all owners. All right, getting through it here, but this slide, I'm not going to speak to each of these items, but what we wanted to do was provide you with a side-by-side comparison or a look at the procedure of establishing a Rule 314 cap. And then we wanted to look at the procedure and the information that was provided as part of the Wells Ranch CDP. And what we find is, even though the Wells Ranch CDP predated Rule 314, much of the elements, both substantive and procedural, that were required under Rule 314 were part of the Wells Ranch CDP. And we think that that's probably twofold. Again, Noble had the benefit of the changes to the Act when we developed this plan, so we knew we needed to go above and beyond what prior Rule 216 required. But also, I think Rule 314 was largely framed, again, by the foundation that Wells Ranch CDP set. So a few things to note. Rule 314E, which is, again, governing caps, identifies roughly 19 materials that must be made part of each comprehensive area plan. And when we looked back at the CDP, all but 3 were included with the CDP, and those were DI community maps. This is not a DI community. Surface owner maps, we had surface owner list, and then groundwater maps. But the CDP included maps of residential building units. It included infrastructure maps, wildlife maps, and aquatic species maps, electrification plans, infrastructure plans. All of those elements now required under CAPS were already part of that CDP. A couple of other items: CAPS must be posted to the commission website and made available for comment. That did occur with the Wells Ranch CDP. It was always available on the commission's website, and comment was invited and was received. And then another item we wanted to mention is that 314 FC provides the parties that have to be noticed of a cap. And when we went back and looked at our notice list, it mirrors the notice list that's now required under CAPS. So all of the parties that would have to be noticed under CAPS were noticed of the Wells Ranch CDP. So again, I think just speaking to how closely the CDP really mirrored what is now Rule 314. A couple of other unique characteristics, and what we wanted to say here, how I want to frame this is, these are unique characteristics of what will be the OGDPs inside of the Wells Ranch CDP. So what's a little bit unique about reviewing each of the OGDPs you'll be asked to look at here instead of standalone OGDPs or piecemeal submittals. First, these locations within the Wells Ranch CDP have been public for over 3.5 years. So where a neighbor may know of a proposed location in a standalone OGDP a few months ahead of time, here our neighbors have known about these locations for over 3.5 years. And not just that they were public on the commission's website. We've had direct engagement with our neighbors where we've shown them maps and walked them through each of these proposed locations. So this information has been with stakeholders and with the public for a very, very long time, far longer than any OGDP you've seen to date. The other item to note is that each of these locations within the CDP have been approved by Weld County and given final approval, and we imagine you'll hear from Mr. Maxey a little bit more on that in the weeks ahead. But what we also want to underscore, and what I mentioned previously, is that each of these locations within the Wells Ranch CDP have been reviewed and conceptually approved by COGCC. So again, this is a very unique item to note that is unique to the Wells Ranch CDP, and unlike any OGDP you've been asked to review to date, is that the director, the staff, and all of our stakeholders have actually had cause to look at this once before and at least given conceptual approval of the locations. So an element that's not yet been applicable to any OGDP looked at to date. And then I mentioned the siting analysis and the cumulative impacts plans that were also part of the CDP. Again, none of that governing prior OGDPs that you've looked at to date. And then diving in a little bit deeper to how order number 1241 and the OGDP review will work together, because it's a little bit unique. OGDPs within the Wells Ranch CDP, and that's a mouthful, are subject to rules 303, 304, 306, and 307, just like any OGDP you'd review, but they're also subject, each of these OGDPs, to your prior order that established the CDP, being order 1241. That is still a valid binding order of the commission and one that Noble is complied to follow. So a couple of items in particular from the text. Order 1241 directs the staff to review future Form 2As to ensure they're consistent with the CDP. It certainly doesn't guarantee the commission will approve those Form 2As, but it does require the staff to determine that what Noble's submitting to you and what we've submitted to you already is consistent with the order that you entered. So that's critical. It's an obligation on the operator and the one that we feel we have to follow. The finding of suitability that was issued by the director and made part of the final order also laid out a really excellent framework for how I think the commission may look at approval of these OGDPs. And we've got the text here, but the finding of suitability envisioned that the staff would first review the 2As and the OGDPs to determine if they meet with the rules in place at the time, and we cited those rules, just like any OGDP, to determine if those locations were consistent with the CDP, and then to determine if they're suitable and have necessary mitigation measures to alleviate potential impacts to public health, safety, welfare. And if not, of course, then we'd have to investigate alternatives. But we think that that's a really helpful way to guide the commission in the weeks ahead in how you need to look at the OGDPs in relation to the order. So just like CAPS Rule 314, it's clear that CAPS do not guarantee an operator will receive approval of a final location or OGDP. The same is true of the CDP. That authority still rests with you in the weeks ahead to grant final approval. But approval of the CDP and conceptual approval of the locations is still a finding by the commission that the plan and the locations are consistent with the act. So it allows us to move forward with this type of plan on this landscape level and drill down into individual OGDPs. Excuse me. So a couple of other items to note, and then I'll wrap for today. We want to highlight some of the cumulative beneficial impacts to oil and gas, to development through the CDP. Again, you're going to hear a lot about this in the coming weeks from our witnesses, but at a high level, implementing the CDP is really going to drive some great impacts, beneficial impacts to the environment and to our neighbors. A few of them listed here is implementation of the CDP is going to allow for the plugging and removal of existing legacy wells. It will allow for implementation of advanced technology and best-in-class pad design, and then ecosystem and habitat restoration. If you give me just one moment here. I've been talking for a while, and if you can't tell, I know you've heard from me before. My children have given me the first cold of the season, so thanks to them. Shout out to them for that. So I'm not going to walk through this entire slide. Really, this is for pre-reading and then reading in the weeks ahead. But what we wanted to do was highlight for you some specifics on how each of those elements are going to work with respect to planning measures and then benefits to the public. Excuse me, I'm the only one in here. So with respect to legacy wells, there are 555 old legacy wells that will be accelerated for plugging and removal in the entire CDP area. So far and away the highest number that you've seen to date. And as I mentioned, this is going to greatly benefit the surface owners, the residents, the tenants, and the environment. We're restoring all of that acreage and vegetation back to its original state. And then again, all of those point source emissions will be removed, and all of those truck trips associated with those legacy wells will be eliminated. With respect to technology, the CDP and implementing the CDP will allow for Noble's EcoNode design. So again, the operational corridor approach to development. It will also allow Noble to implement best-in-class technology. Its modern flowback design, which is essentially no flowback, eliminates or creates zero uncontrolled emissions. We also will be implementing a bulk and test separation style on the facilities, again, removing point source emissions. And then with respect to electrification, the CDP really allows Noble to work in a more meaningful way with the utility providers in the area to electrify wherever possible. So with each OGDP, you'll hear that that's going to vary based on utility providers' availability. But with respect to OGDP 1, for example, next week you'll hear that 100% of the facility and the drill rig will be electrified in OGDP 1, and that's a big driver from the comprehensive plan. Excuse me, I won't speak to each of these, the last two slides, but what this is a breakdown of what I just told you. Again, 555 legacy wells that will be removed in this area through implementation of the CDP. You'll hear next week in OGDP 1 alone, 105 legacy wells will be plugged and removed. That's far and away the largest number that we've seen from any project to date. So a significant benefit to our neighbors. And then you see to the right, we've summarized the emissions in tons per year that this will eliminate with respect to VOCs and NOx. And then this slide also then underscores the truck trips that are reduced from these types of impacts. Again, we'll go through this more next week and in the weeks ahead, but wanted to highlight some of these benefits for you now. So this is the last of my slides, just in time for my throat to go dry. But I do want to just close by thanking you all for your time today, thanking the chair and each of you commissioners for allowing us to provide this overview. We hope that it's beneficial for you, especially as we move forward into actually permitting the OGDPs in the weeks ahead. So what we're hoping is that not only does this remind you of the CDP itself, and how it interplays with the OGDPs, but we'll also hopefully reduce some of our presentation time in the weeks ahead because we won't have to repeat some of this information. So we really appreciate the time, but we also appreciate the commissioner's time, the director's time, and the staff's time over the last 3.5 years, because this has been a very collaborative project, as all comprehensive planning is. We've engaged not just with COGCC, but CDPHE, CPW, Weld County, and all of our neighbors. And it's really through this engagement that we've gotten to a place where we've got a robust plan that's been approved by the commission, and now we get to come forward and permit individual aspects of that plan. We really believe that CAPs and CDPs are critical tools for evaluating cumulative impacts and then looking to ways to mitigate those impacts. But really, it's not till the permitting stage where we're about to embark with the OGDPs that the benefits of those plans are envisioned and can actually be effectuated. So we're really excited to start the the process now of actually permitting the Wells Ranch CDP so that the benefits of the plan that were underscored in all of these documents can actually be put into place for our neighbors and for the environment. So that concludes my comments, and we are here for questions. And should you have any today, and then of course we'll be before you here in the weeks ahead to answer more questions on this project.
Thank you, Ms. Fulcher, for the presentation. Do commissioners have questions? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Ms. Fulcher, for the overview. Not having been on the commission when this all was created and under what circumstances and rules, it's helpful to have the context. I think, maybe AAG Mercer is going to have some input into this. I'm trying to figure out this kind of overlay of pre-Senate Bill 181 rules versus now the new rules that we're under and how we apply them as we're looking at the individual OGDP applications within the CDP. And I'm hearing like consistency with 181 with the CDP. The CDP has some pieces that are consistent because it was done pre 181. But I think I'm also hearing that as we're reviewing the individual OGDPs, we review them with an eye and the layer, the lens of Senate Bill 181 and those requirements. I just want to make sure that I'm understanding appropriately.
And Ms. Fulcher, to follow up with that question, as director, or former director, I'm familiar with the finding of suitability. If you want to sort of speak to that and some of the parameters that were put in to what is conceptual location identification versus the insurance that the OGDPs would comply with the permitting regime in place at the time the Form 2A is submitted, I think that would be helpful.
Sure, absolutely, Chair, and thank you for the question, Commissioner McGowan. I think maybe it's helpful to start by informing you all of what Rule 216 provided, because I think that's where a lot of the language in the finding of suitability was brought forth. Under prior Rule 216, comprehensive drilling plans, when an operator submitted its CDP, with its CDP, all of its planned locations, the commission would look at those locations and then they would essentially be given final approval. So you'd still have to submit a Form 2A just for tracking purposes. That's how the commission tracks locations and gives location ID numbers. But the locations themselves were approved, given final approval as part of the CDP process under Rule 216. And when Noble was submitting the Wells Ranch CDP, of course, recognizing that your mission change rulemaking was underway, I think the commission did not want to give final approval to those locations, knowing, consistent with Rule 216, knowing that your rules were about to change and the permitting process was about to change. And so instead of giving final approval, the commission gave conceptual approval. And I think in practice that operates very similarly to preliminary approval under a CAP, which is essentially that the commission and the director and the staff have looked at a high level, at a landscape level, or macro level, if you will, at each of those proposed locations, and determined that those proposed locations can move forward, are sufficiently protected to move forward to the stage of being submitted as an OGDP. But just like CAPS, you don't get the final approval for that location until you submit the OGDP in the Form 2A. So there's no guarantee, and this is stated in the finding of suitability, excuse me, in the order, that you all will give final approval to each individual OGDP or location. That power still rests with you. But it's that we can move forward with presenting this plan to you because at a macro level, if you will, or conceptual level, you've determined that these locations are in keeping with the Act, and that the plan itself is in keeping with the Act. So I'm going to stop there and see if that answers your question, or if you have follow-up, and then I don't know if AAG Mercer wants to augment my answer there a little bit. So I'll wait for follow-up. And at least for,
Sorry, I was muted. If I may, Commissioner McGowan, let me read a piece of the finding of suitability. I think it'll help clarify. Here, Noble and the director have reached agreement that the proposed CDP will generate a vested right to operatorship, but no vested rights as to actual specific locations. Consistent with this agreement, Noble will revise its CDP to indicate only conceptual locations, which will require commission approval through the future regulatory state to be enacted under SB 19-181. Ms. Fulcher, are you in agreement with what I just read?
yes.
Okay.
Yes.
Commissioner McGowan, follow up?
Okay, so I'm trying very hard not to get into deliberative process already and what we know is coming. But I had questions about, for example, these conceptual locations, which the commission, it sounds to me like the voluntary commission purposefully said, these are conceptual locations because we know this thing called Senate Bill 181 is coming, and the commission might have a different perspective or a different lens that will be applied to these conceptual locations. And then therefore, whatever the new commission or the Senate Bill 181 lens would provide opens the door to commissioners saying, how was this location chosen? How do the new Senate Bill 181 rules apply to these conceptual locations within the CDP? Is that correct? Like, we are still looking at them now with the 181 rules, which require things like looking at alternative location analysis when you're within 2,000 feet of a home, for example.
Mr. Chair, if I may, Commissioner McGowan, I think that's right. I mean, what bears repeating is that your rules under SB 181 will apply to all of these OGDPs. So for example, the alternative location analysis that is triggered by 304 when certain criteria are met, Noble has undertaken that for the OGDPs you're about to consider and will continue to do so for future OGDPs within the CDP. So even though we have conceptual approval of the locations, that does not eliminate Noble's requirement to provide you with alternative location analysis. So you'll see that just like you would any other OGDP. That works a little differently for CAPS, but because this was a CDP, we still provided you and are providing you with that alternative location analysis. So where it is maybe a little bit different is with respect to siting requirements, and we'll get into this in the weeks ahead. But there is an important element of 604B2 related to CAPS and CDPs that allows for the siting of locations between 501 and 2,000 feet when a location is part of a CDP or CAP. So that's one unique area of your rules that's only applicable in these limited circumstances and is applicable in large part because of all of the community engagement that's already been undertaken. And you'll hear a lot about that in the weeks ahead. But I think what you said at the outset is right, that your rules and all of the requirements that are SB 181 are still applicable to all of these OGDPs. Nothing changed there.
So I'll recognize Commissioner Messner here in just a sec. I want to acknowledge the CDP and the Noble approach. I think it is the right approach. I want to acknowledge that this was done after 181, but before our mission change rules. And I want to acknowledge that you still need to comply with our mission change rules, which I think is exactly what you're saying, including potentially an alternative location analysis for each location. It's a tricky spot. And it's not, I guess I want to acknowledge from my perspective that that's not easy. And so there's a balancing act, right, on the CDP and the conceptual locations versus insurance of compliance with our current rules and regulations. I, for one, will suggest to my fellow commissioners that at some point before we review the first OGDP under the Noble Wells Ranch CDP, that perhaps it would be helpful to have an executive session with our lawyers so that we can get some legal advice as to, how to correctly balance these points that are there. So that's my thought. We can certainly try to accommodate that ahead of the first hearing. So with those thoughts out there publicly, I now recognize Commissioner Messner.
Thank you, Mr. Chair. You read my mind. I was actually going to request the executive session on this topic and reviewing of the CDP and the OGDPs associated with it, specifically around Order 1-241 and Rule 604B2. So.
Good. Great minds think alike. AAG Mercer, AAG Davenport work with Ms. Larson to sort of set something up so that we are well equipped to be able to sort of tread through these fields with that first OGDP. And that doesn't diminish any positiveness from your presentation, Ms. Fulcher, and with regard to your client, Noble and Chevron's approach to comprehensive planning, which is something that we really appreciate. And you'd get credit for that. So we're not diminishing that at all. So, but we just want to make sure that we are fully equipped to work through the OGDPs when they come before us, if that's okay. And I would recognize Ms. Fulcher if you had any comments about any of this.
Thank you, Chair. No, understood. And I think that was exactly why we felt that it was maybe helpful to start with this overview today, because we do recognize that this is another first step for this commission. I mean, you've never yet reviewed an OGDP within a CAP, let alone an OGDP within a CDP that carries with it the intended kind of nuance of being approved at the time it was. So, I think we understand that fully. We hope that some of how we framed it today for you and then how we referred back to the finding of suitability helps. Again, the OGDPs that you'll see in the weeks ahead we have complied with the rules. Like the ALA, you'll see it. You're going to see a lot of the same elements, frankly, that you would see in any OGDP. But nevertheless, we want you to keep in mind that there is still this outstanding order governing the entirety of this acreage that is also still applicable. So I think if you have occasion to meet with the AAG Davenport and Mercer on this, I think that also makes sense to talk through this a little bit ahead of actually diving into the substantive dockets.
Yeah, and I couldn't agree more, and I really appreciate your being before us this morning and providing sort of the global context to allow us to understand that and then tee up an executive session ahead of the first OGDP review, which I think is coming up next week. So thank you very much for that. Further questions from commissioners? Commissioner McGowan?
Thank you, Mr. Chair. So just as this commissioner's perspective, I am very interested in seeing ALA and substantial equivalency and the things that are important under Senate Bill 181 in protecting sensitive receptors. So I'm looking forward to digging more into that and hearing how the operator considered those pieces.
Any response, Ms. Fulcher?
Just thank you, Mr. Chair. Duly noted, Commissioner McGowan, we've been working as a team already in refining our presentations for you for next week. And I know the team is listening, and we will take care to address those elements in the weeks ahead.
Great. Perhaps we should have this sort of hearing discussion on other OGDPs.
It may well serve us all. Who knows? Time will tell. It certainly will help shave off some time from our hearing next week. Hopefully, we'll see.
Yep. Further questions from commissioners? All right, seeing no further questions, we will thank you, Ms. Fulcher, again for the presentation. Thank you for having your team available, and we will look forward to hearing from you in the upcoming weeks for
Yes.
the Noble Wells Ranch OGDPs.
Thank you very much. Thank you, Chair. Thank you all.
Okay. At this time, commissioners, I think that we are going to hear from Scott Cuthbert concerning variances and the process. And am I coming across okay or not?
You're kind of echoey.
Huh. I haven't changed anything that I'm doing, and I have my brand new microphone. So can you hear me okay now? Okay. Deputy Cuthbertson, do you want to give us an overview of the variance process that you guys have initiated in anticipation of our variances we're going to hear this morning?
Thank you, Chair. I did think it would be helpful to just make the commission aware. We've been working diligently to continue to implement the rules as they have changed through mission change and financial assurance and the other rulemakings that have happened. And as you have reviewed your packets for today, you probably have noticed a little different director response in regard to some of the variance applications that you'll hear today. And I just thought it would be helpful for you to understand what we've implemented that led to those, to the responses that you've seen. As we have worked to implement the mission change rules, specifically 502B, where it speaks of the concept of a ministerial-based variance, even though appreciatively that's very hard to define, and it is not defined per se in the rules, but certainly has a concept, a sufficient discussion regarding the concept that that we have attempted to implement. What you'll see going forward, subject to additional fine tuning as we continue to try to improve this process, as we do many of our processes, you'll see 3 levels of director response in regard to variance applications for a variance. And there, I think the most helpful way to think about it is in a tiered construct. Three sort of tiers of review. The first tier would be a ministerial review. We have attempted to conceptualize at least what constitutes a ministerial application. And I'm just looking for my notes. I lost them as I joined here, sorry.
Let's take your time. We'll give you an opportunity to find the notes for sure.
The concept of ministerial is laid out in 502B, right? And so as we have conceptualized what that means, this is not a definition, but to give us examples of what we might consider a ministerial is where an application requires the submission of data that maybe has been provided in another way. And the operator is saying, you already have this data. We'd like a variance from having to submit this thing. It's a paperwork kind of variance. A subject matter that may be considered moot due to the passage of time or some other development where the action required by the rules is just no longer makes pragmatic sense because it's just no longer applicable, and it's more or less a paperwork or a ministerial kind of consideration. There would be no substantive benefit from the actions taken by the operator to comply to the letter of the rule because it's been rendered moot by some incident or activity or change. We recognize sometimes that there is a benefit in granting a variance either to wildlife or the surface owner to extend a deadline perhaps to get out of a sensitive season or to get away from a sensitive drilling season for wildlife habitat, or that there is some benefit that the surface owner sees related to the activity that might be considered ministerial that has no substantive impacts on public health, safety, welfare, the environment, or wildlife. We recognize that there might be applications where there have been substantially equivalent results attained through a different process or change. And then the last criteria is that we would think ministerial applications have no long-term significant impact on public health, safety, welfare, and the environment. There might be a short-term, for instance, maybe extending an interim reclamation deadline for a few months, given the concept of interim reclamation is that the land doesn't remain unclaimed for years and years and years during the life of the well. Might make sense to extend that interim reclamation deadline for a few months to accomplish some beneficial end. There's no long-term impact from that extension of that interim reclamation deadline, just as an example. So those are all conceptually things that we might consider ministerial. I didn't check each docket in front of you today, but there might be a ministerial based recommendation for approval based on a ministerial. The ones that I can remember are where there was a change where the county changed the zoning of the location, since it was permitted as an oil and gas location, changed from agricultural to industrial, and now has plans to be built out as a warehouse facility. Doesn't make a whole lot of sense to force the operator to reclaim that agricultural land, because the county has since changed the zoning and approved plans for development as an industrial complex, right? That was one that I think we recommended approval as a ministerial activity, because another administrative agency has exerted their primacy, really, in my mind, to zone the land, it's being the county, such that our requirement to reclaim the land to an agricultural standard just no longer makes sense, right? So that might be an example of ministerial. The second tier of response that you will see, so there are 4 different responses that we have conceptualized. One is recommend approval of a ministerial variance if it meets that conceptual understanding. The other 3 would be to recommend approval of the variance based on the substance of the variance, to communicate that we have no objection to the variance, which means exactly that. We aren't recommending approval. We aren't recommending denial or objecting to it. And then the last one is a response that would object to the variance or suggest conditions of approval that would be required for the director to support the variance. So those 4 responses are what you'll see conceptually right now going forward. Like I said, subject to it continuous improvement and fine tuning. And so the top tier of that is ministerial. If it doesn't meet the ministerial conceptually, it's subject to one of those other 3 responses: recommend approval, no objection, or objection, or conditions of approval. In the recommend approval, there's a sub part that's at work that's specifically acknowledging where oil and gas activity has completely ceased. There's no longer any oil and gas activity planned, that all oil and gas equipment has been removed from the site. But the surface owner is specifically requesting something that was constructed as a part of that location be left in place. Typically, it's the access road. They have now used, or it's not contouring the flat pad back to the natural landscape, because they want to use that to stage hay, or to stage equipment, or to build a barn, or just to access the facility for some reason. In reviewing those applications, the director has attempted to balance the co-administrative landscape that the county has, recognizing that we believe the county really has primacy when it comes to land development, land zoning, land management. And the surface owner certainly has property rights that that we want to be aware of and sensitive to and try to balance. And so you will see today some recommendations of approval of variances where the surface owner has provided a written assertion of responsibility to care for the land, and a request for the amenity to be left in place. Like I said, typically it's the access road, or not completely recontouring the pad to the natural topography. And the criterion that we have established to acknowledge those, to reach the response where we would recommend approval of those, is that we do get a written assertion of responsibility to care for the land from the surface owner, and that written request or support from the surface owner to in support of the variance. So in attempt to balance those things, private property interests, the primacy of the county as the administrative agency that ultimately has responsibility to zone and approve improvements to the land, to the property, or the local relevant government. Sometimes it's a city or a municipality that has that. It's at least the county, if not a finer jurisdiction, a more discrete jurisdiction. And so you'll see some of those responses today. And so if those two things, if it's not ministerial, if it's not a surface owner based request for a location where oil and gas facilities have all been removed, the well has been plugged, there's no oil and gas activity anticipated on the land in the future, and we received those written acknowledgements of responsibility and support for the variance, then the third tier would be a subject matter expert review of the tenets or the content of the application. And that's at the point where we would access our technical experts, and we would review the 5 tenets of the application and all the technical merits of the application. If we don't get to that level of review, then we are, I guess I just want to say out loud, we're recommending approval based on what we believe the commission has instructed through the rules for us to consider in terms of those less than full technical review outcomes, which would be ministerial or our perception of the balanced response to a surface owner's request for a location where there's no longer any oil and gas location or planned activity. So that's the background for the responses that you will see in the as you review these variance applications. And I just thought that might be helpful to hear why you're seeing a different kind of response in the applications from the director, and that's all I wanted to share, Chair.
Thank you, Mr. Cuthbertson. Let me see if I can summarize so that I can. So variances at this point have to go to commission, right? Under our new rules. We have variances in which staff will review each variance, and if they find it to be sort of ministerial without adverse impacts to public health, safety, welfare, then it kind of gets a check. Or if it's based upon a surface owner request to sort of leave things in place, even if it doesn't meet the tenets of the regulations, and you don't have adverse impacts to public health, safety, welfare, then it gets a check. And then kind of the third version is like, no, but this variance has some potential significant impacts. And so you're going to bring in your subject matter experts to sort of review that to determine whether that could be, get a recommendation of approval to come to the commission. Is that a summary of kind of where staff's at on this?
Yes, it is.
Okay.
I would just add that our permitting team and hearings liaison are reviewing every application. And just as you say, they identify the tenants that we have identified for them of the different responses. If they think that it is a ministerial or what we're calling a surface owner based variance, it's reviewed right now by the director or her appointee. In that case, it's me currently. I am the one who's reviewing those for that policy level analysis, basically. And if I determine that it's not ministerial or that there is no written surface owner support for the process, or if there's some significant public health, safety, welfare, environment, wildlife impact, or there's some other tenant that needs subject matter expert review, then I am coordinating that response.
Okay, that's good. And I as one commissioner, appreciate this approach. I think we do have variances that we need to work through the system, and this appears to be a thoughtful approach to how we would do that. And today's our first variance day, so we will approach it with those thoughts in mind. I feel like I'm dominating commissioner questions, but are there questions from commissioners? Commissioner Messner?
Thank you, Mr. Chair. Not a question, but a comment, because I appreciate this approach. I appreciate the acknowledgement that that we have expertise on staff that most certainly needs to get utilized in the review of variance applications, and so I'm appreciative of this approach.
Other questions or comments? All right, seeing no further questions or comments, Mr. Custerman, thank you very much for that overview. I'm going to call an audible, and let's take our morning break. It's 10:08. Let's return at 10:18, and then we'll get into the first of several variances. Okay, we will continue with our agenda. We now have on the agenda several dockets involving Kerr-McGee Oil and Gas onshore. Reading them for the record: docket 2111-00215, docket 2111-00216, 2111-00217, and 2111-00218. And I see that we have Ms. Jost with us. Good morning, and we will, I think, start with your presentation.
Excellent. Thank you, Chair. And good morning, everyone. Commissioners, staff, council, members of the public. My name is Jamie Jost, and I, along with my partner, Kelsey Wazelinski, represent Kerr-McGee Oil and Gas Onshore LP on the 4 consolidated Rule 502 variances you have in front of you in the dockets that Chair Robbins just read. I would like to take a minute and just thank Mr. Cuthbertson for the overview he just provided on the variances. We think that that overview is very helpful and very timely for purposes of our hearings as well as the subsequent variances today. So we have 4 variance requests in front of you, and these are made on behalf of the surface owner, Mr. Bradley Byerly. And these were originally submitted to the commission through the administrative approval process in August 19th, 2020. These variances were pending at the time the emission change rules were adopted in 2021. And upon request of the commission staff, Kerr-McGee did resubmit the 4 variances in front of you today to ensure that they were following the emission change variance process. And that submission occurred in November of 2021, specifically November 9th, 2021. The 4 variances are supported through the individual surface owner, and his support letter and waiver are included as part of the record, along with substantive evidence, as well as testimony and exhibits that were submitted under Rule 505 in support of this Rule 502A variance reclamation request for the 4 locations. The director has issued a recommendation for approval, and with such recommendation, Kerr-McGee believes that the director effectively agreed that Kerr-McGee made a good faith effort to comply or is unable to comply with the specific requirements contained in the commission rule or order, that the variance request will not violate the basic intent of the act, that the requested variance is necessary to avoid an undue hardship, and that granting the variance will result in no net adverse impact to public health, safety, welfare, environment, or wildlife, and that the requested variance does contain either reasonable conditions of approval or other mitigation measures to avoid, minimize, and mitigate impacts to public health, safety, welfare, environment, and the wildlife resources. So Kerr-McGee respectfully requests that this commission give significant weight to the director's recommendation and also approve Kerr-McGee's requested relief for granting variances from certain final reclamation requirements in Rule 1004A and 1000C2 for the HSR Fogelman 626A well site, the HSR Stubben 11-26A well site, the HSR Byerly 14-6 well site, and the HSR Russell 3-26 well site. So with that, I would like to thank you for your time and consideration today. I'm going to go ahead and share the presentation and turn it over to Mr. Austin Lee from Kerr-McGee. We do also have Ms. Lynna Scranton on, who will be available for any questions at the end of the presentation as well.
Very good. Thank you.
Thank you, Ms. Jost, and thank you, commissioners, for your time this morning. As mentioned, my name is Austin Lee. I'm an HSE advisor with Kerr-McGee. My primary obligations are oversight of our reclamation programs, as well as our construction and post-construction stormwater programs across the DJ. This presentation is intended to be a consolidated review of the 4 variances packages previously submitted to the COGCC for the Byerly property access roads. A variance was submitted for each individual location, but I'll be speaking to the property and the roads as a whole for this hearing. We're briefly going to cover Rule 1004 and how it relates to the variance requests, as well as surface owner consultation at the time of plugging and abandonment, waiver acknowledgement, and lastly, we'll provide a visual representation of current site conditions for each individual road being requested today. I've also included reference to both Rule 502 and Rule 1004 at the beginning of this presentation, but we'll just transition directly into Rule 1004 and its relevance for today. Just to paraphrase Rule 1004 a bit, all pits, cellars, and rat holes shall be backfilled, gathering and flow lines removed, and debris cleaned up upon plugging and abandonment of a well. Access roads shall be removed, graded, recontoured, and all culverts or similar appurtenances removed with the road itself. Following removal and earthwork, all associated locations should be reclaimed and completed within 3 months or 12 months after plugging, depending on land use of the associated areas. Excuse me. Reclamation in non-cropland areas requires that uniform vegetative cover of 80% comparable to the surrounding undisturbed reference be met before seeking closure, at which time Form 4 will be submitted and an inspection performed by the commission to confirm or deny final reclamation success. Next slide, please. Kerr-McGee is seeking variance of Rule 1004A and 1004C at discretion and request of the surface owner, Bradley Byerly, for completion of final reclamation on 4 auxiliary roads and 1 arterial road formerly used for oil and gas development and production. The red lines shown here on the map to the right identify the associated roads on the subject property to be left in place as to allow for continued property access by the Byerlys throughout the half section parcel in Weld County that they own. In addition to the auxiliary roads and arterial road, the property also has a cattle guard and lockable gate at the southern perimeter, which is just off of Weld County Road 28. which provides, secured access to the property for both the Byerlys and Kerr-McGee currently. That gate is going to be a part of this variance as well and is to remain in place. But outside of that, there are no culverts, roadside culverts or culverts in the access road itself, or additional stormwater construction BMPs, which would require removal or variance under this request. I just wanted to highlight here to the right most of the map itself. The nearest surface water is upgrading and east of the property. Any associated runoff or erosion that could potentially come from the road being left in place would naturally flow away from this surface water, which in this case is West Spear Canal. Final reclamation for all associated wells and facilities on the Byerly property was completed in October 2019 and March of 2020. Again, as shown on the map here, Kerr-McGee has reclaimed approximately 7.04 acres relative to the 4 well sites and their associated production facilities and flow line disturbance removal. Kerr-McGee is seeking to waive approximately 3.92 acres of cumulative access roads per the request of the surface owner from final reclamation obligation. All well sites and production facilities reclaimed in the past years are currently monitored under our reclamation program. These locations continue to be monitored and maintained seasonally or more frequently if needed until Rule 1004 for final reclamation is met, at which time we'll send a third-party biologist out to the location to perform a quantitative veg assessment and then determine whether it's truly met the requirements or not. I just want to highlight, on this property we're looking at here, there are no additional wells or facilities that remain or await plugging and abandonment. What you see in this little representation here is the last of what's on Bradley Byerly's property. Kerr-McGee initially consulted with Bradley Byerly on November 21st, 2019 concerning final reclamation on the property following plugging and abandonment of the associated wells and facilities. At the time of consultation, Mr. Byerly had requested that all 2-track lease roads associated with our former wells and locations be left in place to provide continued stabilized access to various portions of the half-section parcel that he has. Mr. Byerly expressed concern that if the roads were removed and subsequently reclaimed, he would have trouble accessing the property through sandy soils notable in that area and would also inevitably end up causing unwarranted damage to the property by rutting, as a result of general vehicle and equipment travel off-road. Kerr-McGee completed final reclamation at each well and facility location on the property, which included road base removal and working surface removal. We did compaction relief, topsoil, and amendment incorporation, and then eventually seeding and stabilization. I just wanted to note that these locations were planted with a mix suitable for sandy soil in eastern Colorado, also approved by Mr. Byerly. That mix consists of warm and cool season native grasses. This mix is still currently utilized seasonally as we continue to perform maintenance out on each individual site. Mr. Byerly's requests were initially submitted to the COGCC along with a comprehensive variance package completed by Kerr-McGee for each individual site on August 19th of 2020, as Ms. Jost had highlighted as well. The document you see to the right here is a reference cover letter of the associated variance packages that were submitted by Kerr-McGee for all locations on the property. Kerr-McGee has secured signed waivers for final reclamation from Mr. Byerly and believes each individual variance is necessary to avoid undue hardship. I would like to highlight that, again, this is on behalf of the surface owner and it's as to not create additional or unwarranted damage on the property at their request. Kerr-McGee's intent and standard approach for reclamation of plugged and abandoned assets, or interim reclamation for that matter, is to reclaim our entire operational footprint back to its prior land use. This approach allows us to manage and maintain our footprint and push it towards successful reclamation. With that in mind, there's no compensation that was given to Mr. Byerly for leaving the roads in place. Again, this variance request is to keep in good graces with him and to not cause additional damage or degradation on his property. The following slides you see here are just reference to the signed copies of waivers obtained by Mr. Byerly for each location that we're discussing today. Kerr-McGee has performed due diligence to ensure that there will be no net adverse impacts to public health, safety, welfare, the environment, or wildlife resources associated with leaving these roads in place on the Byerly property. All associated roads are of private land ownership and do not see public or commercial use. Leaving the stabilized roads in place is also going to result in little to no additional surface disturbance, which could potentially result in erosion or sedimentation on the property from precipitation or wind. And it will also keep establishment of undesired vegetation or noxious weed establishment on that property to a minimum as best we can. Again, to note, the Byerly property is downgrading to the nearest classified surface water, which is West Spear Canal, and does not, leaving these roads in place doesn't present any harm to state waters. Kerr-McGee has also reviewed high priority habitat buffers, and we'll see that on the next slide a little bit here with a map reference in relation to the locations in this request, and determine that no HPHs occupy the area. Mitigation measures to avoid, again, minimize, mitigate adverse impacts to public health, safety, welfare, the environment, and wildlife resources includes continued management of, again, noxious and undesirable vegetation establishment on the areas that have been reclaimed on this property. And subsequently, those roads will be included as long as we're out there until we meet standards specified in Rule 1004 C2 for final reclamation on those well sites. Thus, Kerr-McGee hasn't submitted any sundry Form 4 notices for final reclamation completion on the well sites as we continue to maintain them to date. So this slide shows a comparison of HPH data between Kerr-McGee's internal GIS database, which utilizes current CPW data set, as well as COGCC's interactive web-based map with the same layers applied. Kerr-McGee's table of contents, it pulls information from the view of extent that you see on the map to the left here. Therefore, there aren't any HPHs or boundaries or buffers that would be shown. I understand it's a bit difficult to see that in the table of contents down on the bottom left of that map. But again, similarly, I wanted to have an additional representation or reference with the map on the right, which is the same CPW layers applied in the CODIS online database, as well as the National Wetlands Inventory layer provided by U.S. Fish and Wildlife. Again, this is just a little bit of a side-by-side comparison to show that we have done a cursory review. There aren't any HPHs within this area that overlap our request, and just wanted to have that highlighted here as we move forward. The next handful of slides are going to include visual representation of each individual location and the associated access road that we're requesting variance from Rule 1004. Photo series relative to each well on the property is starting from the west side of the road and then facing east. And then we took another photo on the easternmost portion of the road facing west, just to provide a comprehensive visual representation of what these roads look like today and the property today itself. And with that, I will turn it back to Ms. Jost for a summary.
Great, thank you, Mr. Lee. And Chair and Commissioners, with that, we would wrap up our presentation and request recommendations for approval of each of the 4 requested variances in the dockets here that you can see on the screen. And those variances are to Rule 1004A and 1004C2, as discussed by Mr. Lee. And with that, that would wrap our presentation, and we're happy to have Mr. Lee and Ms. Scranton come back on screen. I will stop sharing if there are any questions.
Mr. Chair, I think you're muted.
Thank you. Again, I'm playing with a new microphone, and so the mute unmute is different going into year 3 of Zoom meetings. Thank you for the presentation. According to my agenda, we did not have any further presentation from staff or otherwise. We do have a director's recommendation of approval, I believe, based upon what we heard from Mr. Cuthbertson earlier. So I will look to my fellow commissioners if there are questions for the panel. Commissioner McGowan?
Thank you, Mr. Chair. No questions, but a comment. I appreciated the visual that you provided because sometimes you're trying to understand what's left behind and what it looks like and what the impacts might be. And so I'm appreciative that you provided that as part of this presentation. And I'm appreciative that the owner was the one requesting this, and sounds like you've gone through the work with the property owner to figure out what the variance request looks like.
Commissioner Messner.
Thank you, Mr. Chair. I concur with Commissioner McGowan's comments and would move approval of dockets number 211100215, 216, 217, and 218 as presented.
Second.
We have a motion and a second. Is there further discussion or deliberation? Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate that and concur with the points that have been made. I also just wanted to point out on the cover letter, just for the future for Ms. Jost or Mr. Lee, that there's a statement in there to the landowner that the commission will grant a variance that waives compliance provided the surface owner and KMOG enter into a reclamation waiver agreement. And I would just maybe think about softening that language pursuant to kind of the deliberative process here. That said, no further comment, Mr. Chair.
Any additional comment, deliberative notions, etc.? Commissioner Cross.
Thank you, Mr. Chair, and I'll apologize. Similar to Ms. Fulcher, I am also getting over a cold from the kids coming home from school. I'd just like to make a quick comment that, I agree with the sentiments previously expressed, and, I think it is important where a landowner is requesting that something stay, that we do follow those private property rights and interests. So I just thought I'd make that comment quickly.
Agree. Isn't it nice that we're back in a world where you can get little sniffly things from your kids and not like get freaked out? All right. We have a motion and a second to approve the variance requests on the dockets that I read out at the beginning of this part of the hearing. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Variance requests are granted. Thank you very much, Ms. Jost, for you and your panel.
Great. Thank you, everyone. Have a good day.
All right, we will continue forward with our docket. We now will have docket number 211-000-197, as well as 211-00198 and 2203-00053. These are variance requests by Karis Piance LLC. Mr. Pashala will be presenting, and I see that he is with us. Good morning.
Good morning. I just want to make sure that my representatives from Karis are with us. I see Adam and I see Frank. So I think we are in shape to proceed.
There's also a Lynn Scranton with us. Is she on your team?
If she is, she's not planning to be a presenter for these applications.
Okay, actually, she just left the panel. So looks like we got Adam Roll and Frank Jimenez. So I think we're ready to go.
Excellent. Well, good morning, Mr. Chair, and good morning, commissioners. As you know, my name is Joe Pershala with Wellborn, Sullivan, Meccan, Tooley, and I am appearing here today on behalf of Karis Piance LLC. With me today are Adam Roll, the contract EHS specialist for Karis, and Frank Jimenez, landman for Karis. I as well would like to thank Mr. Cuthbertson for that very helpful presentation on variances this morning. I think it gives great direction and understanding for all the parties and the commissioners and staff as well to understand these applications. Karis's applications would fall under that second tier of variances that Mr. Cuthbertson described as having director recommendation for approval and written surface owner assertions of responsibility to care for the land. These applications, there's 3 of them in front of you today. These locations are on non-cropland. And Caris is requesting variances from certain final reclamation requirements under Rule 1004A and 1004D, which I will summarize. 1004A provides in relevant part that following plugging and abandonment of well, the operator will alleviate compaction, restore and revegetate well sites, associated production facilities, and access roads to the same standards as established for interim reclamation under Rule 1003. Rule 1004D provides in relevant part that final reclamation of all disturbed areas shall be considered complete when all disturbed areas have either been built upon, compacted, covered, paved, or otherwise stabilized and minimize erosion, or a uniform vegetative cover has been established to at least 80% of the pre-disturbance levels, or equivalent permanent physical erosion reduction methods have been employed. In docket, so those are the two sections of the rule that we're requesting variances from. In docket number 211000197, that is for the Thurnburg Unit 63-9, N91W 17 Southeast Northeast location is location ID number 391848. That is located in the southeast northeast of section 17, township 3 north, range 91 west in Moffat County, Colorado. There's only one well in the location. That was the Thurnburg Unit 19 well, which has been plugged and abandoned. And all reclamation is complete, save for recontouring the well pad surface, a closed pit, and access road to the request of the surface owner. And that's for which the variance requests relief. For docket number 211000198, that is the Courier 610 South S96W 21 Southwest Northwest location ID 312500. And that's in the Southwest Northwest section 21, township 10 South, range 96 West. And that's in Mesa County. There's only one well on that location, the Courier 4-21, and that well has been plugged and abandoned. All reclamation is complete except for the well pad surface and the access road being left intact at the surface owner's request. And that again is for what the variance is requesting relief. In docket number 22030053, that is for the Bevin location. I'm going to save all the numbers and letters. It is location 312536 in the northwest southeast of section 30, township 10 South, range 96 West in Mesa County. And on that, there's only one well as well, the Bevin 1-30, and that well has been plugged and abandoned. All reclamation is complete, save for recontouring and revegetating the access road at the request of the surface owner. And again, that is the relief that we're requesting. As mentioned, for each of these, Caris has obtained a final reclamation agreement with the relevant surface owner, where the surface owner has expressly requested that the pad, the pit, and the access roads, as applicable, be left in their current condition for their own personal use. To obtain the variance, and as further set forth in these applications, which I'll briefly summarize, Caris has satisfied Rule 502B 1 through 5. It has made a good faith effort to comply or is unable to comply with the specific rule requirements for which it's seeking a variance, including having obtained a surface owner waiver. The requested variance will not violate the basic intent of the Act. And I note that in the mission change rulemaking, the Commission in the statement of basis and purpose had stated that the Commission recognizes that a surface owner should have the right to request that its land be reclaimed in a manner that may vary from the Commission rules. Third is that the requested variance is necessary to avoid an undue hardship. Here, the final reclamation of these relevant areas would result in additional surface disturbance and impacts to the land and environment, and thus would be contrary to the express terms of the final reclamation agreements and the desires of the surface owners. Under 4, granting the variance will result in no net adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Caris's EHS specialists have evaluated the impacts associated with these variance requests and determined that there would be no net adverse impacts. And lastly, the requested variance the rule provides that the requested variance contain reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts to public health, safety, welfare, and the environment. And it's Caris's position that given the condition of these unreclaimed areas and the installed stormwater controls, which these are sufficient to avoid and minimize or mitigate adverse impacts such that no additional conditions of approval or mitigation measures are necessary. The relevant local governments are Moffett and Mason County, and Caris gave notice to both the counties and the surface owners. No petitions or interventions were received. The director has issued her recommendations, which recommend approval of these applications. And therefore, Caris submits that these applications satisfy the Conservation Act and the commission rules, and respectfully requests that the commission adopt the director's recommendations and approve these applications. And with that, I will turn it over to Mr. Roll, who will provide more specifics on these locations and the variance requests. Thank you.
Good morning, Mr. Roll.
Good morning, and thank you, Mr. Pershala, and thank you, Commission, for your time. My name is Adam Roll. I am a program scientist with Confluence Compliance Companies, LLC, and an embedded consultant with Caris Oil and Gas. I act as a reclamation specialist with Caris. As Mr. Pershala indicated, we are here to discuss 3 surface owner variance requests. The Thornburg, which I will refer to as the Thornburg Unit 19, the Courier 421, and the Bevin 130. So I'll walk through Caris's process in these surface owner variance requests and the evaluation of the sites, the brief overview of each. So the Thornburg Unit 19 in Moffett County, it's located between Meeker and Craig, just east of Highway 13. This well was drilled in 72 by Fuel Resources Development Company. It was plugged 22 years ago by Tom Brown Incorporated. The operators have changed. Caris acquired the asset in 2017. Surface owner consultation was completed by Encana in 2016, in which the surface owner requested that the access road and well pad remain uncontoured to provide access to this portion of the property for ranching and outfitting operations.
Adam, may I interject? Did you want to share your screen? Were you working up your presentation?
I thought I was. Thank you.
Let's give you a second to screen share.
How are we there?
We're good. We can see the screen, Thornburg Unit 19.
Great. Thanks for that. All right. So this is an older location that Caris acquired in 2017. There we go. So these photos represent the current conditions of the site. This is the well site itself, facing southeast from the center. This is the access road facing the well site. So the surface owner has requested that this portion of access road, along with the entirety of the well site, not be recontoured. The road provides them access to this portion of the property for ranching operations and outfitting operations. And leaving the site flat provides them a place to access with trailers or perhaps camping. So while evaluating these sites, following the surface owner's variance request, Caris looks at all applicable COGCC rules and any potential impacts to public health, safety, welfare, the environment, wildlife resources, water resources, etc. So this map represents hydrology evaluation of the location. The nearest receiving water is Stinking Gulch up here to the east. The well site has a northwesterly aspect, and any surface flow would travel into this ephemeral drainage and eventually confluence with Stinking Gulch about 2 miles north. So the well site is revegetated. There's no evidence of erosion or surface degradation. So Caris has concluded that leaving the well site in its current condition, not recontouring it, would have no impact to surface waters. This map represents the wildlife, the desktop portion of the wildlife evaluation. So this site, being up in the mountains, is in 8 different high priority habitats. You can no longer see the background imagery because these habitat layers are overlapping to the point where we just get a nice purple here. The dark blue indicates cutthroat trout habitat, although this dark blue follows that ephemeral drainage I mentioned earlier, which has 3 to 4 cattle and wildlife earthen dams and ponds before it eventually confluences with Stinking Gulch. So really there's minimal potential that could really be cutthroat trout habitat. The remainder of the wildlife in the area, or the high priority habitats in the area, include mule deer, sage grouse, and elk production and migration corridors and such. As the well site is revegetated with perennial grasses and shrubs, Caris does not believe there will be any negative impact to wildlife in the area. The property is pretty wild, and the landowner's operations appear to be limited based on the condition of the access road. That doesn't seem to be hardly any traffic on it. So we do not expect there to be any impact to wildlife. Move on to the Courier. This location is in Mesa County, just east of the town of Mesa. It was drilled in 1981 by Coors Energy Company and plugged in 2018 by Caris. Prior to plugging the well, Caris conducted a surface owner consultation in which they review just the operations of closing the well site and the plans for final reclamation. During this consultation, the surface owner requested that the access road and well pad remain flat, graveled, and not be recontoured. This would allow the surface owner to utilize the well site for staging agricultural implements and hay storage. These photos indicate the current conditions of the well site. Top left shows the well pad facing northeast from the southeast corner. Lower left shows the well pad facing south from the northern perimeter. On the right shows the access road facing the well site from the entrance. This map indicates the area the surface owner is requesting a variance for, including the access road and well pad that remain graveled and not recontoured. The area in blue indicates the reclaim disturbance, former interim reclaim, current final reclaim, in which Caris is monitoring and maintaining to ensure that those revegetated areas meet all 1004 requirements. The hydrology resource map indicating hydrology resources in the area. This well site would have a northerly flow of storm water, eventually hitting the Plateau Creek up here. Blue circles indicate water wells. We did a further evaluation of the water well just east of the well site, and based on 1959 permits, that water well is actually located just east of this home up here. But furthermore, leaving a graveled surface has minimal potential to impact water wells, as the variance request pertains to the surface, not the subsurface and aquifers. This site is stabilized via gravel. All portions of the site that are not graveled are in process of revegetation to prevent erosion, topsoil loss, site degradation that would have the potential to impact surface waters. The wildlife resource map indicates that the area is within 3 high priority habitats, including mule deer severe winter range. Actually, this bighorn sheep migration corridor and elk severe winter range, these are actually outside of the well site. So the well site itself is just within the mule deer severe winter range. Caris does not believe that leaving the access road and well pad in its current condition would impact wildlife, as the agricultural operations the surface owner wishes to conduct are common in the area. This is an agricultural corridor within the Plateau Valley. And during severe winter range, the deer, if you hang out up there, you'll just see them in the hay fields and along the Plateau Creek there. The well site's up in the sagebrush and not ideal forage for mule deer. Moving on to the Bevin 130, this location is also near the town of Mesa and Mesa County. It was drilled in 1982 by Coors Energy Company, plugged in 2013 by Encana Oil and Gas. Final reclamation of the well pad itself was completed in 2015. Encana completed the initial surface owner consultation that year. Caris, after acquiring the asset, completed an additional surface owner consultation in 2020. This surface owner is requesting that the access road and all associated infrastructure remain in place. The associated infrastructure includes gates and a bridge, small bridge over a drainage. This access road is the primary access to the property itself. So it's a little hard to tell here. The property lines indicated in the thin black. This is a flag property line that left this portion of the property as the primary access. This property is landlocked otherwise. The larger property itself, the section was subdivided in 2001. Each subdivided section includes a strip of access to KE Road over here. Photos indicate the current condition of the access road and well site. Top left is the access road facing east from the well site. To the right, we're facing west towards the well site from the access road entrance. Bottom left shows the condition of the well pad reclamation, which, based on Caris's annual reclamation monitoring and a quantitative vegetation survey conducted by a third-party consultant, the well pad does meet vegetative cover standards under Rule 1004, and also based on a COGCC final reclamation inspection conducted just last week, that well pad meets revegetation standards, and the well site itself meets standards for closure, provided that this variance is approved. The Bevin 130 is the hydrology evaluation here. It is within a public water system buffer, and that's based on Mesa Creek here. It's a water source for Ute water, for municipal water source. As the access road and well pad are stable without any evidence of erosion, degradation, or sediment discharge, leaving that road in place, Caris believes will not have any impact to municipal water sources. The blue circles indicate the domestic or commercial water wells in the area, as I mentioned on the courier. As the variance request pertains to the surface of the land, Caris does not believe it will have any impact on water wells. Wildlife evaluation of the courier. The location is within 4 high priority habitats. revegetation and stabilization will prevent sediment discharge into waterways, which will protect aquatic sports fish, which Tate Creek here, as well as Mesa Creek, are designated as aquatic sports fish management waters. Mule deer severe winter range and winter concentration areas cover the well site. Revegetation of the reclamation area will ensure, adequate habitat for mule deer. And again, this access road is not utilized very often, so we wouldn't expect any increased impacts to mule deer in the area. It's a rural residential area. There's bald eagle roost sites in the cottonwood trees along Mesa Creek. As this land use is similar to the whole surrounding area around the town of Mesa, Karis does not believe that little traffic on that access road would impact bald eagle roosts. All right, in conclusion, Karis has completed surface owner consultations compliant with the rules. The surface owners have requested portions of these well sites remain and provided Karis in writing these agreements. Karis does not believe that any of these variants, should they be approved, will have any negative impact on public health, safety, welfare, or the environment, and asks for commission's agreement there. Thank you very much for your time.
Very good. Thank you for the presentation. If we could, there we go, stop the screen share. I can see all the commissioners a little bit better. Mr. Pashala, did you have anything further, closing remarks?
Nothing further, Mr. Chair.
Okay, very good. Commissioners, questions for the panel? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you, Mr. Roll and Mr. Priscilla, for the presentation. Very informative, and I would concur with Commissioner McGowan that the visuals are very helpful, so thank you for including them. Just a couple of questions and a couple of comments. My first question would be the major concern with any type of disturbance is weed persistence and proliferation. And it looked like reclamation had taken place that precluded that for the most part. I did see in one of the photos vegetation coming up through the gravel on one of the gravel pads. And so I just wanted to know if you could talk just a little bit further about what you've done to control weeds and to ensure the lack of weed proliferation in the future going forward, and who would have responsibility for that. And I think that's probably directed at Mr. Roll.
So I think you're speaking to the Courier, where you might have seen some cheatgrass coming up through that graveled surface. So Karis does employ weed management contractors. We also conduct site inspections throughout the growing season. The Courier itself has been treated 2 times this year for noxious weeds. The graveled surfaces, as Karis is liable for the location, are treated with a bare ground herbicide in the spring. The surface owner agreements detail that once the well site is closed with the COGCC following a passing final reclamation inspection, the surface owner is then takes full responsibility for management of the surface.
Thanks for clarifying that, Mr. Roll. I appreciate that. I wanted to make sure that was on record. And, that's the case, of course, with all private land in Colorado, that the surface owner is generally the manager of that land and generally responsible for controlling their weeds. So it kind of reverts back to the surface owner control. So thank you for clarifying that. I don't think I saw this mentioned in your presentation, but I did see in the materials that there was a pit that was intended to be left uncontoured in order to serve as a water catchment. I think it was on the Thornburg, but you'll have to clarify for me. And I just wanted to clarify there that there was communication with our sister agency, the Division of Water Resources. As I know, water catchments are very controlled in Colorado. Wanted to know if there had been any kind of a process there or what that looked like.
So during the review, there was no consultation with the Division of Water Resources. If Karis can confidently say there will be no impacts to surface waters or public water resources, additional consultation is not completed at this time.
Thank you for that response, Mr. Roll. I would just note for the record that there may be additional consultation. While it's not required by our regulations, there might be additional consultation necessitated with the Division of Water Resources to ensure there's not improper water catchment left behind by a COGCC initially approved topographical pit.
Oh, I'm sorry, Commissioner Ackerman. I thought you were referring to the public water resources at the Courier, but you're referring to the Thornburg Unit 19 here that I've pulled back up. Stock ponds, which are what these catchments were left at, they're not regulated by the Division of Water Resources. And therefore no consultation was completed regarding the Thornburg. And I'll speak into a little more detail regarding the historical pits. They were closed in 1999, both historical pits. This area just to the west of the Thornburg, through a review,
Mr. Roll, if you're thinking you're sharing, I'm not seeing it, so.
thank
There we
you.
go. There we go.
I'm a rookie to Zoom, a Teams man through and through. So the historical pits, the coordinates listed in the COGCC database, like many of these older pits, are inaccurate. They give the nearest center of the quarter section. So, but based on aerial review, this area to the west is potentially the historical pit spoken to in the surface owner agreement. So this pit was closed in 1999. There was, based on the records we were able to acquire, some recontouring done in the pit to turn it into a wildlife and cattle pond. Does that answer your question, Commissioner Ackerman?
It does very much so. Thank you, Mr. Roll. I really appreciate the detailed response. One final comment for me is that, one of the concerns we have sometimes along roadways is, erosion and being left in erodible conditions. I think in these narrow cases where we have a landowner requesting continuation of a road that's been engineered and put in place, with engineering, certainly that's preferred to this commissioner as opposed to just overland, ad hoc creation of roads. And so in this narrow circumstance, I think the erosion risk is lessened by leaving a road in place rather than allowing, overland travel. So I appreciate your details on that as well. And I would also echo Commissioner Cross's earlier comments in our last agenda item that I very much appreciate the coordination with the private landowner and the private property rights that are associated with this request as well. So that's all I have, Mr. Chair. Thank you.
Thank you, Commissioner Ackerman. Other commissioners with questions or deliberations? Commissioner Messner.
Thank you, Mr. Chair. Thank you for the presentation on the different variance requests. And I'm wondering, my understanding is that, one of the significant factors to habitat fragmentation is the development of roads in certain areas. And understanding that some of the roads that are being considered left in place here may or may not be utilized very often. But looking holistically at habitat fragmentation, in the area, and understanding that one of the intents of reclamation is to, remove some of that fragmentation to improve habitat fragmentation and to lower the intensity for any kind of future oil and gas development. Was there any consultation with CPW to make any kind of determination on whether or not these would cumulatively impact habitat fragmentation in this area?
Thank you, Commissioner Messner. In these instances, the Colorado Parks and Wildlife were not consulted as they are private surface. It is Caris's belief that the surface owner, and per Rule 1001C, has a say in the way it is reclaimed. As the surface owner requested these roads stay, wildlife fragmentation is not evaluated in detail. I will speak that in cases such as the Thornburg 19 limited use and the road is revegetated, whether it's natural or potentially was seeded 22 years ago following well abandonment, that I don't foresee any large impact to habitat in the form of fragmentation. And additionally, leaving this infrastructure in place per the surface owner's request may prevent surface owner constructing or utilizing their own road, which may have additional impacts and degradation to the environment not already in place.
I appreciate the answer. Do understand that I'm looking at this through the lens of 502c4, which indicates that granting the variance will result in no net adverse impact of public health, safety, welfare of the environment, and specifically wildlife resources. And so that's why I ask these questions and try to understand if CPW has been consulted in this situation. But I appreciate your answer.
Thank you.
Further questions? All right, seeing no further questions, does any commissioner desire to initiate deliberations and or a motion? Commissioner Cross?
I would move to approve the variance as requested.
That's variances plural, right?
Correct. Yeah.
Very good.
Second.
Motion and a second. Is there further discussion? Commissioner Ackerman, then Commissioner Messner.
Thank you, Chair Robbins. And again, I appreciate the presentations today. This is a bit of a global discussion and a comment, I guess, not intended for discussion, but I think, as we're kind of just venturing into this new format of approving variances, I think it would be helpful for those listening and for those operators that are presenting to us to not just simply state that they have a belief that there's no impact, but to Commissioner Messner's point, to add a little detail as to what the biological substantiation is for that to be no lasting impact for those conditions in our regulations to be met. So that's just a general comment. That said, I also concur that I think coordination with CPW on those kinds of statements as the state's expert are wise as operators come before us. Those are my only comments, Mr. Chair. Thanks.
Thank you, Commissioner Ackerman. Commissioner Messner.
Thank you, Mr. Chair. Agree with Commissioner Ackerman that I think it, particularly as I review this through the lens of the variance requirements for no net adverse impact to wildlife resources and looking at habitat fragmentation and the intensity of activity in particular areas, particularly as I look through the lens of any kind of future development that may occur. I think these unreclaimed areas have to be considered, in that analysis of future development as continually impacted areas. And so while I acknowledge that this particular situation may may be able to be approved. I think that the cumulative impacts associated with allowing these areas to stay unreclaimed, and as we look at future impacts of future development and habitat fragmentation, these things will all get considered cumulatively. So I think that needs to be considered, and I think it is wise to consult with CPW as our state professional agency around wildlife in these considerations. So.
Further discussion? All right, seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Pashala, for you and your team's presentation.
Thank you, Commissioners.
All right, everybody good to keep moving along? All right. Dockets number 2203-00066, 2208-00201. This is a oil and gas development, or two oil and gas development plans, TPR pad 25A, TPR pad 25B, CPX Piance Holdings LLC. We are looking to elevate Mr. Ratliff and Jennifer Biver. Not sure if I said that last name correctly.
Yes, Chair Robbins, it'll just be myself, Dale Rath,
Okay.
and the other panelists on behalf of CPX, Gwen Brodsky, Nick Kurtenbach, Brian Clark, and Tom Feldkamp.
You need each of those folks elevated?
Yes, please.
All right, we're working on it. Give us a sec. And Ms. Amaro, you're somewhat jumbled. Mr. Ratliff, I've got Ms. Brodsky and Mr. Feldkamp. Who else are we looking for?
Looking for Nick Kurtenbach and Brian Clark, both with CPX Piance Holdings.
Okay, Ms. Amaro, if you could try to identify those folks.
See Nick?
Yep. Okay, I see Mr. Kurtenbach. Repeat the last person that you're looking for.
Ms. Morrow, the last person we're looking for is Brian Clark.
Mr. Clark.
I don't see Mr. Clark in the panelists, the attendees. Would he be under a
Miss-
phone number?
Miss Amaro, there is an attendee named Brian. He doesn't have a last name.
Spelled with a Y?
I'm sorry?
Is it Brian with a Y? B-R-Y?
Yeah, with a Y.
That
Is
would
that-
be him probably.
Then let's elevate Brian with a Y with no last name. Then we'll have him video himself and we'll see if we got the right Brian.
Brian, we can begin.
I'm here. Can you guys see me?
Nope, but we can hear you, Brian, and I can tell you that's the right Brian.
That's the right
Okay.
Brian.
So
Okay.
the condition that we can begin while Brian sorts out his video. That's not an issue.
Very good.
So why don't I
That's right. Go for it.
Okay, so let me start by sharing my screen. Okay. Can everybody see that?
We can see it. We can also, it's not in presentation mode, which is fine, but just FYI.
Okay, let me stop for a second then, and I'll take 1 second. And Still not in presentation mode?
Yeah, we still see two slides, like the current slide and the next slide.
Yep. Still see it? Gosh darn it. I don't
There you
know.
go. Now you got it.
Better?
You're
Okay.
winning. Yep.
Thank you. All right. Thanks for dealing with that for a second. Commissioners, Chair Robbins, good morning. Thank you for your time. My name is Dale Ratliff. I'm with Williams, Weiss, Pebble, and Ferguson. I represent CPX Peons Holdings, LLC. CPX would like to thank the commission for its time today and thank staff for its time and their review and effort in the OGDP applications in front of you today. We'd like to particularly thank Dave Cubesco for his role as the OGLA reviewer and to the leadership from Sabrina Trask. With me today on behalf of CPX is Nick Kurtenbach, CEO of CPX Peons Holdings, LLC, Brian Clark, Operations Manager for CPX, Gwen Brodsky, the regulatory and permitting consultant from AATA Technical on behalf of CPX, and Tom Felcat, geologist from High Ground Interests on behalf of CPX. CPX's presentation today is going to provide you with an overview of the proposed OGDPs, an introduction to CPX and the TP Park Ranch property, an overview of the planning and environmental improvements that preceded the proposed development in front of you today, a background on CPX's existing well pad 25A, its high priority habitat, consultation history, and BMPs, a description of the proposed temporary water support pad 25B, its consultation history and BMPs, and finally, the OGDP request for approval. CPX is requesting approval of two OGDPs for locations on CPX's privately owned TP Park Ranch, the TPR Pad 25A OGDP and the TPR Pad 25B OGDP. The locations are in Section 25, Township 7 South, Range 94 West in Garfield County, approximately 10 miles south of Rifle. The Pad 25A OGDP requests approval to amend an existing oil and gas location. There will be no new surface disturbance. CPX owns 100% of the surface acreage and 100% of the mineral acreage. The OGDP conforms to Basin-wide Order 1229 for the Williams Fork and Isles Formation, and no spacing orders needed. The location does not require an alternative location analysis under Rule 304. The location is greater than 1 mile from any residential building units. CPX received a waiver from CPW for the portion of the existing pad that is within the Rule 1202C buffer for cutthroat trout, and there's no variance requested. The Pad 25B OGDP requests approval for a new temporary water support pad. The pad will support water recycling for completions and significantly reduce truck traffic. The pad will not have wells or a mineral development area. The pad will be in use for less than 3 years from the commencement of tank operations to support TPR well completions, and then the pad will be decommissioned and the area reclaimed. CPX owns 100% of the surface acreage. The location does not require an alternative location analysis. It's greater than 1 mile from any RBUs. It's not located in high priority habitat, and there's no variance requested. No public comments were received on either application, and no petitions were filed on either application. Because this is CPX's first OGDP in front of the commission, we wanted to provide a little background on CPX and TP Park Ranch. CPX is a privately held natural resource development company headquartered in Houston, Texas. CPX is an operator in good standing with COGCC, and CPX is current on its financial assurance. CPX privately owns the 4,300 acre TP Park Ranch in Garfield County, which is shown in red on this figure. TP Park Ranch was historically used for logging, grazing, and shale extraction, and it was initially developed for natural gas in 2008. There are two already constructed existing well pads on TP Park Ranch, pads 25A and 36A. Pad 25A has 2 producing natural gas wells and 1 drilled but uncompleted well. And all told, the 2 existing well pads take up about 10 acres of the 4,300 acre ranch. CPX began the planning and preparation for its proposed development on TP Park Ranch approximately 5 years ago. Through this process, CPX is consistently and openly coordinated with CPW, COGCC, Garfield County, BLM, and the Forest Service. CPX's approach to the development of TPR Ranch has been comprehensive and thoughtful. And now I'm going to turn it over to Nick Kurtenbach to speak in a little bit more detail about TP Park Ranch, CPX, and CPX's proposed development plans. Nick?
Thanks, Dale. Good morning, commissioners, and thank you, staff and commissioners, for having us here today. We appreciate the hard work from staff, as Dale said, and the forum provided here to have a dialogue with the commission. I'd also like to say we too share the sentiment Commissioner Mesner shared in his opening comments today, that we're proud to be operators in the state of Colorado, and we're excited to be here today and have this opportunity to tell you about CPX and our project at TP Park Ranch. CPX has owned and operated TP Park Ranch since 2015. During our 7.5 years of ownership, we have adhered to a strict code of land stewardship and have undertaken a number of pre-planning and environmental improvement initiatives. Our singular focus since 2015 is how can we best develop TP Park while adhering to our cornerstone belief of land stewardship. That plan, many years in the making, is before you here today. TP Park Ranch is a unique property. It presents unique opportunities. It's a canvas for long-term development where CPX owns the surface and the minerals, and along with certain challenges such as terrain and seasonality that require long-term planning. Commitment to the land, investment, and collaboration with multiple agencies such as U.S. Forest Service, Colorado Parks and Wildlife, and the COGCC have allowed us to take a long-term vision with TP Park. We have been master planning this development here before you today since 2015, long before emission change and recent commodity price spikes. Our team has been collaborative and thoughtful in our approach, and now we feel very prepared to develop this asset in an efficient and responsible way. Our first phase of infrastructure investment and environmental improvements began about 5 years ago, with those improvements featured and labeled in color on the left-hand side of this slide. Many of these were multi-year projects serving the long-term purpose to best position CPX to develop TP Park Ranch in the most efficient, least impactful manner as possible. The largest project occurred in 2018 when we rerouted and reconstructed the former U.S. Forest Service Road 824, approximately 750 feet away from high priority habitat in Beaver Creek. This project was a heavy lift with the Forest Service and CPX collaborating on a new road that significantly upgraded public access. Also shown here is our Pad 2 tank terminal for water and condensate storage, which was also constructed in 2018 and is actually located off of TP Park Ranch on a parcel CPX owns near Garfield County Road 317. Additionally, in 2018, we closed and reclaimed a former produced water pit used by the previous operator. That area is now revegetated and is a field used for livestock grazing. Dale, next slide, please. A bit more on environmental improvements here. This slide illustrates the road reroute constructed in 2018. This image shows you where the old road alignment was to the left, which was essentially right on top of Beaver Creek. And as you can see, we designed and financed moving Forest Service Road 824 away from Beaver Creek high priority habitat, shown here in the movement from left to right or east to west. We buried the surface gas flow line that was formerly installed along Forest Service 824 by the previous operator, and also buried new condensate and water flow lines in a shared trench with the new gas flow line. The installation of this system significantly reduces truck traffic for the duration of our project. The flow line system is bidirectional and flows between Pad 25A and Pad 2 tank terminal, pictured here and mentioned in the prior slide. The installation of Pad 2 tank terminal was a big upgrade as it eliminated liquids load-out traffic on the Forest Service 824. We then reclaimed and vegetated the closed piece of the old Forest Service road to avoid sedimentation. That reclaimed road is now a public use trail. CPX also built stormwater diversions and armored culverts, in many cases by hand up and down the new Forest Service road. We're also proud of the new Trailhead Parking area we built for the Forest Service lands to improve public recreation access. Next slide, please. Slide 7 further illustrates some of these improvements I just spoke of. From left to right, you have the new Trailhead Parking area that improves access for skiers, hunters, hikers, and provides large turnaround area for horse trailers. The new stormwater controls include the hand-laid rock culverts I mentioned to avoid erosion and runoff to Beaver Creek. Photo 3 shows the surface gas line along the Forest Service road that we eliminated. And finally, the new Pad 2 tank terminal eliminates commercial liquids loadout traffic across the Forest Service, which is also where our gas meets the sales line. Next slide, please. And here's Pad 25A, which was constructed in 2008, so it's been around a long time. We're requesting approval from COGCC to continue to use Pad 25A. It's 5.5 acres with a 2.6 acre working pad surface. It'll be reduced to 1.8 acres after interim reclamation. Our intent with this project is to turn over as little dirt as possible, thus no additional disturbance is needed on Pad 25A. Pad 25A has 2 wells in production since 2014, along with 1 drilled but uncompleted well. We propose to add 34 new natural gas wells and convert the uncompleted well to a Class 2 injection well. The UIC well will be used for TP Park water disposal only, no third-party water. It will significantly reduce truck haul traffic for produced water. And with that, I'll turn it over to Gwen Brodsky, who provides regulatory support to CPX. Ms. Brodsky will further describe high priority habitat.
Thank you, Nick, and good morning, commissioners. I am Gwen Brodsky. I'm a regulatory and permitting consultant with IATA Technical. The slide in front of us is showing high priority habitat. A portion of the constructed Pad 25A is within the 500-foot buffer under 1202 C1R for cutthroat trout, and it's shown in blue in this inset. The topography in this area doesn't flow in either direction for the high priority habitat. To the south is uphill. To the north is actually cross gradient in a dry woody area, so that the down gradient direction is northeast, with Beaver Creek approximately 1,440 feet away. So the design for new key production equipment for this pad, including storage vessels and separators, was moved outside of this 500-foot buffer. And in the next slide, we wanted to spend a minute on consultations. CPX conducted consultations and coordinations throughout 2021 and 2022 with CPW and COGCC and Garfield County. And several of those visits were on the location. CPW documented 4 individual waivers or agreements with BMPs for Pad 25A. One of them was 1202C for high priority habitat for cutthroat trout. There was 304 for an alternative location analysis based on that 1202 waiver. There was 1202 for staging within 500 feet of what's a mapped intermittent. And there was 1202 with BMPs for the new flowline corridor. And in the process, CPW stated that it incentivizes the use of already disturbed locations and BMPs like berms, stormwater controls, and secondary containment when no adverse impacts are anticipated. And we wanted to talk in the next slide about those BMPs for Pad 25A. This pad is about 14 years old. So with regard to high priority habitat and the movement of soil, it's stable. It has steel secondary containment sized to 150% of the largest tank. That liner is sprayed in to optimize the seal. There are 2-foot high earthen berms. They're compacted to 95%. The berms and the cut slope on this pad are already vegetated for stability. There's a 6-inch drain on the center of the pad. It captures stormwater, and then that drain is piped to a perimeter diversion trench and a catchment basin, and the solids settle in the catchment basin. They're pumped out for disposal, and the stormwater evaporates. There's no staging or storage near water. CPX is on site 24/7 during completions and daily during production. A new SCADA system will provide remote monitoring for operators. The wells have emergency shutdown capability. And the operations manager and pumper both live within 15 minutes of this site. Nick is going to similarly walk us through pad 25B.
Thanks, Gwen. Pad 25B will be a temporary water support pad used only during well completions at TP Park. We invested a lot of time and thought into finding a low impact and efficient solution for water management here. The mechanism to recycle water. 25B is to be built over the flat surface of an existing private TP Park road, as shown in the photo here. Pad 25B is not in high priority habitat. This plan underscores our commitment to land stewardship as evidenced by the temporary nature and design of 25B. We plan to use 25B safely and efficiently with proven technology, and then reclaim it as soon as possible, restoring the surface back to its original state. Simply put, 25B allows us to recycle water that will be delivered by a water pipeline that's already constructed, shown in earlier slides. 25B allows for faster and more efficient drilling program, and ultimately less time on the ground. The equivalent to 25B storage is as many as 300 frac tanks and the haul traffic to deliver them and move water. As a point of reference, Beaver Creek is approximately 930 feet downgrading. The location is heavily engineered to protect the environment with multiple levels of secondary containment. By using this pad, CPX can avoid freshwater withdrawals from hydraulic fracking and completions, and significantly reduces truck trips for this project. The tanks we've selected are proven technology that fits the characteristics of the Piceance Basin well. Similar tanks and recycling are currently in use across the western slope. The storage capacity of 25B is up to 150,000 barrels amongst 12 tanks for use, up to 3 years from operations commencing. Storage for the water is needed because the recycled water isn't available on demand. We have to manage water balance as water is available via water share from a third party to start well completions, and then is produced by our own wells to continue those well completions. To take advantage of recycling this water, we've designed 25B, a pad with multiple layers of containment and contingency planning. In summary, we're investing in 25B to provide us the flexibility to manage recycled water in the least impactful way to TP Park and the surrounding area.
And on this slide, I can describe additional consultations that occurred for the pad. CPX did additional pre-application outreach, additional on-site review, and further consultations specific to 25B. CPW provided its agreement with BMPs to temporarily reroute an approximately 310-foot section of the TPR road that would now be under the pad for its stormwater controls. COGCC provided guidance on water and frac support pads. And there was an additional on-site review, once with COGCC and again with COGCC during a large multi-agency on-site with CPW, COGCC, Garfield County, BLM, and the Forest Service. And in the next slide, we can talk in some additional detail about BMPs that were designed specific to 25B. So the recycled produced water will be sourced from a third-party reclaimed water pond and its pretreatment. And then the water from well completions on TPR will pass through a 4-phase separator, low-pressure vessel, and produce water tanks with vapor controls, and then to a 10-micron filter before transfer to pad 25B. The pad is engineered for contingencies. Each tank will have an isolation valve. Tanks will be inside of lined secondary containment designed to 150% of the largest tank. And that secondary containment will be a 4-foot high, 10-inch thick synthetic muscle wall. It has 8-foot long interlocking sections. They're secured with locking pins. And then a 50 mil polyethylene liner overlaps the muscle wall and gets clamped to the top. There will be no vehicle access inside the muscle wall. That muscle wall forms a barrier. And then there's an additional 2-foot high earthen berm surrounding the muscle wall. It will be compacted to 95% soil moisture density. A 5-foot diameter steel sump will be installed inside the muscle wall to capture and contain natural drainage or a potential small leak. A larger spill would be captured in the sump and inside of containment. And then it would be pumped to an emergency standby tank on CPX's pad 2 using CPX's existing buried water flow line. The manufacturer's representative will oversee tank installation inspection, and testing. Operators will be on location 24/7 during completions, inspecting and monitoring tanks, and an operator will be on location approximately daily between completions. And when completions on TPR are finished, residual water in the tanks is planned to be disposed of using CPX's proposed UIC well. And the tanks will be taken out of service, they'll be dismantled and removed, and the location will be reclaimed.
Thanks, Gwen. And thanks, Nick and Gwen, for the background on CPX, TP Park Ranch, and the proposed OGDPs. The one takeaway that I'd like to reinforce is that CPX began this process in 2017 with the goal of constructing the systems and infrastructure necessary to support natural gas development on TP Park Ranch in the most efficient and least impactful manner possible. CPX is the sole surface owner and mineral owner of the proposed development area. There are no potential surface owner conflicts or mineral owner conflicts, and yet CPX has still committed itself to developing TP Park Ranch with the smallest footprint possible and in the most efficient manner possible. CPX has 2 OGDPs in front of you today. CPX is requesting approval of the Pad 25A OGDP for the continued use of existing well pad 25A, an approximate 415-acre mineral development area, the development of 34 new natural gas wells in addition to the 2 existing producing wells, conversion of 1 existing drilled but uncompleted well into a Class 2 UIC well, approval of the associated Pad 25A Form A, and approval of the Form 31 intent and Form 33 intent for the Class 2 UIC well. CPX is concurrently requesting approval of the TPR Pad 25B OGDP for an approximate 4-acre location to serve as a temporary water support pad, and approval of the associated Pad 25B Form 2A. Again, we thank you guys for your time today and look forward to any questions.
Okay, thank you for the presentation from the panel. At this time, do commissioners have questions? Commissioner McGowan?
Thank you, Mr. Chair, and thanks for the presentation, and thanks for kind of fleshing out, I think, for what was for me a lacking piece for cumulative impacts. So when I was trying to map out everything that was happening here, it feels to me like there's going to be a lot of reduced truck traffic because you're piping in water from different locations. You're using an existing location for a frac surface. You're and so I was appreciative of you kind of fleshing out kind of how you're going to minimize truck traffic and vehicle miles and how many visits, etc. I am curious to know your response to staff's recommendation, because it looks like you're going to, after you do, like I call this phase 1, you're going to have phase 2, which is drilling then on 36A, if I'm remembering correctly, and staff's recommendation to amend kind of this OGDP grouping that we're going to maybe approve today. We have to deliberate. And so I was wondering if you could respond to that staff recommendation. These pieces all, for me, do work together, and it's helpful as a commissioner to see these pieces and how they're all going to piece together, including kind of your future development.
Yeah, I can help answer that on the front end. Yeah, we've been coordinating with staff. We obviously reviewed the director's recommendation, and we don't have any concerns with that recommendation. You're correct, Commissioner McGowan, and that our next potential proposal, the next proposal in the development of TP Park Ranch would be to develop additional natural gas wells on pad 36A. We're hoping to have that OGDP in, say, by the end of this year or early 2023. And we think it is a fine proposal to amend, because as part of that package, one thing we'd be doing is potentially amending the pad 25A OGDP to use that as a temporary frac support location for developing those pad 36A wells. So it would be appropriate to amend this application to include that. And then to the extent staff would like to coordinate on analyzing the cumulative impacts that have already been submitted to you today, like the Form 2B impacts for pad 25A, and incorporate those into the pad 36A OGDP package, we're more than willing to coordinate with staff on that proposal.
Thank you. That's helpful. And once I did finally understand the back and forth and how everything is interrelated, I think it's actually pretty creative, and I appreciate the looking at using existing sites, looking at a partnership with TEP and using some of their recycled produced water, I think was pretty creative and looked at minimizing impact. So I was appreciative of that. Thank you.
Great question. Thanks for fleshing that out. Further questions? Commissioner Messner?
Thank you, Mr. Chair. Thank you for the presentation and the application. I did have a question along the lines of Commissioner McGowan as we look at the cumulative impacts and future considerations for pad 36 and future utilization of pad 25A, I think it was. During your consultations with CPW, was there discussion about the future proposals considered in the future as we looked at this holistically, which is really what the OGDP applications are designed to do? And was there consideration or discussion with the additional impacts associated with pad 25A in the consultation with CPW?
Yeah, I can take I'll take a first pass at that and maybe pass it to Gwen for a little bit, but yeah. Following mission change, when the cutthroat trout buffers expanded and also the requirements around them changed, the first thing we did was engage with CPW, and we did it on both pad 25A and on the potential development plans for pad 36A. And so we've actually already consulted with CPW about pad 36A and have a written waiver for the use of pad 36A for the portion within 500 feet, and a written recommendation for a variance for a portion of pad 36A that will be within the variance buffer. CPW has been on multiple site visits to see the entire development plans, including just a recent one here in July that involved CPW, COGCC, and Garfield County.
Thanks for that. It wasn't clear as I was reviewing the application whether you were looking at these expanded use of 25A in the future, or whether CPW's consultation was just on the elements associated with this application. And so that clarification is helpful.
Further questions, Commissioner Ackerman?
Thank you, Mr. Chair. I appreciate that. And just a couple of comments and a question. My question is about the injection well. And again, I would echo my fellow commissioners in that I appreciate the innovative approach to trying to reduce truck traffic. I know this isn't mapped as high priority habitat. I'm personally familiar with TP Park Ranch and its excellent elk habitat. And so I very much appreciate the work that you're doing to minimize the traffic associated with this development. As far as the injection well that you intend to use, the uncompleted well, can you talk a little bit about the, does anybody know about the stratigraphic profile of that well? And you know, we didn't go into much detail as far as I could tell about where that water is being injected into, what formation. If it's there, I missed it and I apologize.
Yeah, Commissioner Ackerman, I am going to have to tap out on that question and pass it over to Tom Feldkamp, who can help answer all questions about the geology and injection zone.
Yes, Commissioner, thanks for the question. The injection zone will be in the Isles Formation, which is below the productive Williams Fork Formation. We purposely put it down there below the produced zone so that the producing wells in the Williams Fork would not be penetrating the injection zone. So Isles Formation below the Williams Fork productive interval is where we're intending to inject water.
Thank you, Mr. Feldkamp, and I'm sure you included that in the materials, so I apologize for missing it. I appreciate the response to that question.
It is. There are a number of illustrations in the documents we provided.
Thank you so much. I also, CPW's insured me on the HPH that they have worked through the issues that they had, and appreciate you engaging them early and often, and encourage you to continue to do so. This is a great site and appreciate the work that's been done. That's all I have, Mr. Chair. Thank you.
Very good. Thank you, Commissioner Ackerman. Further questions? Okay, seeing no further questions, we move into deliberations. Does anyone desire to initiate deliberations and or make a motion? Commissioner Messner?
Thank you, Mr. Chair. Just some considerations for any future motion is that I think we've got three things here that perhaps need to be included. We've got two conditions of approval that have been requested by staff that I think, I mean, at least from this commissioner's standpoint, I think is important to incorporate into any motion to approve. And then there's also a request to require consolidation of any future OGDPs that I think is important to memorialize as part of a motion to approve this application. And so I didn't know if any commissioners had concern about any of those elements that they be incorporated into a motion.
Commissioner McGowan?
Thank you, Mr. Chair. And I agree with what Commissioner Messner is bringing up. Just for point of clarification for me, are the conditions of approval already included in the recommendation and the application, or do we have to include them? That's not clear to me. So for my clarification, it would be helpful to understand what we're.
AG Mercer? You're muted, Ms. Mercer.
Thank you very much, Mr. Chair. Sorry about that. So my understanding, and I would invite staff to correct me if I'm missing anything here, is that the two COAs are part of the application. They are written on the Form 2A that is before you and addressed in the director's recommendation. So I would consider those to already be part of the application. Does that answer your question?
Commissioner McGowan?
Thank you, Mr. Chair. And then in regards to the second piece, which is the commission's desire to see any other components related to these two OGDPs be viewed as amendments to what we might approve today. Can we commit future commissions to a decision like that, or do we just make our intent clear today via discussion? How does that work?
AG Mercer?
I think perhaps the best way to handle this is through just direction to staff that, you know, if it's the desire of the commission to go with staff's recommendation to consider the future OGDPs in that framework, to direct them to go forward under that plan. That way it doesn't bind future commissions to accepting that form of application. It just sort of sets up the process as outlined by staff, which I think is appropriate here.
Thank you for that. With that, do we have a motion?
I'll move approval of the application as presented.
Second, with direction from the commission to approve staff recommendation to address future applications related to this OGDP as amendments. I'm not sure I'm saying that right, AAG Mercer, but that's our intent.
Commissioner Messner, cool with that friendly amendment?
So amended.
Want to re-second your newly revised motion, Commissioner McGowan?
I shall re-second.
I don't know if that's a word, but okay, we have a motion and a re-second. Are there further discussions amongst commissioners? Commissioner Cross.
Thank you, Mr. Chair. And I'll just say that I appreciate the time and effort put into the planning of this. I agree with some of the prior comments that, you know, the thoughtfulness of creative ways to work together with other agencies and try and minimize impacts, I think is important. So I appreciate that.
Good point. Further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. The project is approved. Thank you, Mr. Ratliff, to you and your panel.
Thank you, commissioners. Thank you, everyone.
Thank you, commissioners.
All right. Turning to page 3 of our agenda, we have one last docketed matter, the McLean Energy enforcement default action, docket number 2205-00116. Do we have someone from staff that is going to frame the issue?
Mr. Chair, yes, we have Ryan Monk, the enforcement officer, who we will bring in to present on this matter.
There we go. I apologize for the delay.
No problem. Nice to see you and good morning.
Good morning. This is my first time appearing before you commissioners, so I'd like to briefly take a moment to introduce myself. My name is Ryan Monk, and I'm an enforcement officer appearing on behalf of COGCC staff this morning. I started in this position just over 4 months ago, so I'm still very fresh, but I'm excited to have my first opportunity to appear before you all today.
Thank you very much. Great to see you and welcome to the team.
Thank you very much. If I can just have one moment to get my screen shared here. I have a presentation to share with you all. Can you let me know if you're able to see my starting slide here?
We can.
Perfect. So in this hearing, I'm requesting that the commission enter order finding violation number 830 against McLean Energy Incorporated. McLean Energy Inc., operator number 10602, is the operator of record for the Van Scoik 1 well, located in Adams County, Colorado. This is McLean's only well in the state of Colorado. Staff issued an NOAV to McLean in January of 2020 for violations of rules 210 sub B, 210 sub D, 309, 603 sub F, 605, 907 sub E, and 907A. In June of 2020, staff issued an NOAV to McLean for further violation of Rule 309 for failing to submit their Form 7 monthly report of operations. In June and August of 2020, respectively, staff issued 2 additional NOAVs to McLean for further violations of Rule 309 because they failed to submit their Form 7 monthly reports of operations. Staff's goal in this matter is to claim the bond of a non-responsive operator that has ignored COGCC staff and rules for almost 5 years. And I will provide evidential context to support that claim. As of September 21st, 2022, McLean has not responded to the 4 NOAVs issued in 2019 and 2020, or the inspection conducted in October of 2020. And the most recent production reporting for McLean's single well goes back to August of 2017. McLean has not responded to numerous emails from staff or to phone calls made to the numbers McLean has registered with COGCC, the most recent of which call was made on Friday, September 16th. Here's a screen capture from this COGIS database, which shows that McLean has not reported any production data since August of 2017. A notice and application for hearing for an August 26, 2022 hearing was sent to McLean on June 9th, 2022, and published in the Daily Journal and Brighton Blade on June 10th and June 16th, 22, respectively. McLean has not responded to or participated in the enforcement process. The Commission should find that McLean failed to comply with the requirements of Rule 210 sub B, which requires that an operator install permanent signage providing emergency contact numbers at tank batteries and wellheads. These issues had not been corrected as of the most recent inspection. The Commission should find that McLean failed to comply with requirements of Rule 210 sub D, which requires that an operator provide an accurate flammability rating on their tanks. This issue had not been corrected as of the most recent inspection. The Commission should find that McLean failed to comply with the requirements of Rule 603 sub F, which requires that an operator keep their facilities free of unnecessary equipment and trash. These issues had not been corrected as of the most recent inspection. And staff further noted additional corrective action was needed for weeds growing at the location. The Commission should find that McLean failed to comply with the requirements of Rule 605, which requires that an operator maintain the mechanical condition of their facilities. As of the most recent inspection, mechanical condition issues at the wellhead and pumping unit had not been corrected. The Commission should find that McLean failed to comply with the requirements of Rule 907 sub E, which requires that an operator properly dispose of oily waste. As of the most recent inspection, the stained soil at McLean's wellhead had not been corrected. The Commission should find that McLean failed to comply with the requirements of Rule 907A, which requires that an operator dispose properly of non-E&P waste. As of the most recent inspection, the stained soil at the pumping unit and engine had not been corrected. Finally, the Commission should find that McLean failed on 4 separate occasions to comply with the requirements of Rule 309, which requires that an operator monthly report every existing well, oil and gas well that is not plugged and abandoned. As of today, McLean has still not submitted their delinquent Form 7s. For informational purposes, this slide shows that McLean has a single $20,000 individual cash plugging bond with the Commission. Staff is requesting that the Commission order McLean to return to compliance with the Act and the rules. Staff is also requesting that the Commission order McLean to pay a penalty of $763,456. And you can see the breakdown of this penalty calculation here. And the penalty calculation continues here onto a second page. This penalty was calculated using the duration matrix described in the Commission's enforcement and penalty policy. As all violations are ongoing and uncorrected as of the date of filing, the penalty end date is September 21st, 2022, the hearing date today. Staff is requesting that the Commission consider that the following proposed terms have been standard in the context of previous bond claim orders. Staff is requesting that the Commission order, including requirements that if McLean does not pay the imposed penalty within 30 days of transmittal of this order, that the Director shall revoke McLean's authorization to conduct oil and gas operations in Colorado and foreclose McLean's $20,000 of financial assurance. Staff is requesting that the commission consider that the following proposed terms have also been standard in the context of previous bond claim orders. Staff is requesting that the commission include provisions that allow for the director to, 1, declare McLean's wells orphan wells, 2, investigate, prevent, monitor, or mitigate adverse environmental impacts at the wells, and 3, claim all equipment and saleable products at the wells formerly operated by McLean. Finally, I should note that the commissioners will want to ensure that they have staff's most recent proposed order, which was uploaded to the docket this morning to correct issues with the listed start and end dates and penalty calculation subsequently in the recommended order. Staff therefore asks that the commission approve order number 830. Thank you for your time and consideration this morning.
Thank you, Mr. Monk. I want to stop screen sharing. It'll make me be able to see all my fellow commissioners a little bit better. All right.
Sure thing.
Does staff have any sense of kind of like when was the last time you had verbal or otherwise contact with McLean?
It seems to be the most recent contact of any kind was their submission of their August 2017 monthly report of operations, Form 7. I'm not aware of any response to any actual communication, either by phone or email, that staff has attempted to reach out in the last 5 years.
Okay, so 5 years or thereabouts. Okay. Questions from commissioners for Mr. Monk? Commissioner McGowan.
Thank you, Mr. Chair. Thank you, Mr. Monk, for the presentation. The phone number that you're contacting, is there a message? Is there a person? Is there a voicemail? Is it the company still, or?
They appear to be personal numbers. It does go to, they do go to voicemail. I left one voicemail on each of the numbers that I contacted, but my subsequent calls, I did not leave a voicemail.
Okay, thank you very much.
Other questions, Commissioner Messner?
Thank you, Mr. Chair. Unless I'm mistaken, it seems like in situations similar to this in the past, there have been consideration of requiring McLean or any of its owners or corporate folks within McLean to come to the commission before ever returning to operation in the state of Colorado. I'm not getting the language right. It's just one of those days. But was there any consideration of that in this order?
We, as staff, don't know of anyone left to bar.
But I mean, there is someone that the phone number is going to, and so I guess I'm wondering why we wouldn't just include that provision so that we don't have this situation at some point in the future.
Mr. Monk?
My understanding is that, and I'm maybe mistaken here, but what I believe has happened in this case is Mr. Gene McLean, who is still listed as the designated agent, I believe may have passed away, and his company was passed to his widow, who thereafter struggled to maintain all the requirements that COGCC has and seems to have just kind of abandoned the operation altogether. She is also listed as a contact. She doesn't have an email address listed, but she is one of the phone numbers that I attempted to call.
Okay, thank you for that additional information. That's helpful. I think it's also possibly covered in here by requiring McLean, its successors or assigns to comply with the order, blah, 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 in section E. So I'm comfortable with that.
Commissioner McGowan?
Thank you, Mr. Chair. And Mr. Monk, you might not know the answer to this, but is this well shut in and is it leaking? I'm trying to, so for my own edification, I assume it's going to end up being transferred to our orphan well program, but I'm trying to figure out like if it's just leaking right now and we need to do something pretty immediately.
I'm unsure if it's actively leaking. I don't believe staff thinks that it is actively leaking, but I believe that it is shut in.
Thank you. Mr. Chair,
Yes.
I would move that the commission approve order number 830.
Second.
Motion and a second. Is there further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Monk, for the presentation. Well done. You've now passed your first presentation, and we look forward to hearing from you often.
I look forward to that too. Thank you, commissioners.
All right, commissioners, that takes care of the agendized business for the day. Does anybody have anything else? Seeing none, do we have a motion to adjourn?
So moved.
Second.
A motion and multiple seconds. All those in favor of adjournment signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned. Thank you. Thank you, everybody.